page number 1, item number 3 and 4. Page number 2, item 5 and 6. Page 3, item 7. Page mention over.
Left out matter.
All right, so we will be tagged with those matters.
Yes.
Because we have not signed the order, just give the file. No, this is supplementary order. Give the file to them only. Na?
Right.
A separate order will be passed.
Same matter. Same realization.
No, it will be listed. It will be listed. Today it's and it will be separate batch and it will be covered by the same judgment. Now, otherwise, that is appropriate.
Same matter. Rehabilitation left out matter.
You give the cases to the state council so that they can verify. Yes.
We're giving you the photocopies of the mention memos.
I'm supplying matter.
Let them supply them so that we can.
Yes.
Bring Mr. Kuntia, bring the today.
Since 98,
Give the numbers.
and he approved these are honorable court, my lord. Honorable court directed to consider the case as the similar matter has already been disposed of by this honorable court. The state had filed the appeal as well as, and the basis on that, my lord, it has been stayed. My lord.
Have you received the notice?
Yes, my lord.
It will come on 9th of October.
My lord, my case is Patad matter, my lord. Honorable court, my lord, fixed up that on 14. 14 dispense was changed. Thereafter, I have mentioned honorable court again.
We list the matter today itself because we'll release it from Patad. I have no time to write judgment.
My lord,
only to release it from Patad.
Read appeal number 1780/2022. It was scheduled to be listed today, my lord. Inadvertently, it has not come, my lord.
Not inadvertently. Just 12th of October.
This matter has been listed on fixed on 25/9/2023, but not listed, my lord.
Come on 9th of October.
I made a mention before your lordship. Public interest litigation. Interim application has been filed praying for staying illegal diversion of Kalyan Mandap to some other place.
It will come on 5th of October. Give the list.
Miller experiment by 2023 matter related to area salary.
All it will come on 12th of October.
Is not listed. Please give some date. It was yesterday. Kindly give some further date.
So I will give other date. What is the subject matter?
Subject matter is a service related matter. TN graduate teacher.
All it will come on 12th of October.
I mentioned one matter.
The date also October.
I mentioned one matter last Friday that construction is going on by the government on my land. The lordship fixed that on Monday, my lord. It could not be listed. Your lordship may take up the matter today. For admission, my lord. For admission, my lord.
Petition or writ appeal?
Writ appeal, my lord.
11th October it will come.
I may be pardoned to make a
Today, my lord, your lordship can take up.
We are not taking any matters. From today, I will not take up new matters.
Matter. Fiction that 31/7/2023 that not to be listed. In between, I am filed the IA. So kindly be.
It will come on 5th of October.
Let's see. So let's see.
My lord,
Your Lordship, this is a PIL concerning that construction of a ring road over the playground, Your Lordship. In the meantime, Your Lordship, the opposite parties have gone much forward with the construction of the ring road, Your Lordship. So if they continue to do so, the whole petition will be rendered infructuous.
Now, we passed an order, I remember, who is appearing? Mr. Muduli was appearing on. This is a ring road matter.
Yes, I was appearing.
We
That
asked-
Shiva Shakti Club.
Yes, Your Lordship.
So they say that despite our order, given you 4 to 5.
No, that case was listed day before
21.
yesterday. I had received instruction that they are constituting a committee that later, it may be listed any day. I will place the materials on record.
All right, but you don't proceed with the construction. We are fixing a very short date.
Construction, I think not.
No, that only that part, not the
Only
entire
that
part. Only that part.
I think it is not her allegation that construction is going. They want to change the,
No, they want to keep this position of the field intact. What is the?
also may call it tomorrow. I will bring.
All right,
necessary
bring the
facts.
facts over. Let us
Much
see.
obliged, Your Lord.
I may be pardoned to make a small mention, my lord. Read appeal number 1705 of 2023, my lord, under the rehabilitation assistance scheme, and state had gone for read appeal, my lord. And my lord, in the meantime, my lord, the urgency is that the petitioner was directed by the single court for consideration of the representation, my lord. My lord, may I pray the matter for state file petition.
Loan and number, I will just,
Yesterday, all the batch matters have been disposed of.
My lord.
we give the numbers.
Give the number, it will come today
1705 of
also.
2023, my lord.
Come on, it will come on 9th of October.
Obliged, my lord.
But a rate appeal matter, this matter was also directed for listing on the 18th 9, but it could not be listed. This matter relating to approval and the granted in law. This is matter relating to approval and the grant of.
We fix on 5th of October.
But
Because we are not taking new matters. This bench will not take.
very small matter.
No, because ultimately we are on certain matters. Maybe some CAV matters are also to be released. I don't know. So we are not accepting it.
My lord, 5th October.
My lord, my Pathade matter kindly listed tomorrow, my lord.
What matter is listed today only.
No, I have mentioned only
Listed today. Today only for purpose of releasing it. We will not hear the matter.
Yes, Pathade matter. Today, this case is, yes, obliged.
You have to look for a new bench.
Before this temple, I pray Lordship tomorrow, only 15 minutes.
Mr. Mahandi, you have shifted to Jagatsinghpur.
No, man, today I have got difficulties, madam, that's why. It's not Jagatsinghpur.
Yeah. Mentioning a memo or what?
Yes, madam, my junior associate is there, Jagannath Sahu is there. My lord, I am mentioning with your lordship, my associate is having the memo, my lord.
Yes, you mention what the matter is then.
Review petition number 193 for 2023. My lord, the single bench order, my lord, that was challenged with the read appeal, my lord. My lord, that order was passed by the single judge before giving me opportunity of hearing. My lord, that order has been, now it has been impracticable for me to carry out that order, my lord. That's why I filed the
9th of October. 9th of October it will come.
My lord, the data content proceeding has already been initiated, my lord, against me.
Already, only few days. 9th of October, closest date you have fixed it.
I pray for 5th October. 5th October, I pray, my lord. And
5th October, okay, 5th October.
okay.
Lordships, regarding tomorrow, Lordship,
It cannot be. We'll be wasting time only. Cannot be. I am indicating since last 3 days. Don't mention new matters now.
May I call this for judgment. For judgment, W1014 of 2023.
That we have decided then that in the cancellation deed, they have taken a ground that you have misconducted, whatever so that cannot be decided by the registrar. And we have given to raise all the pleas before the suit. So filing for this, there should be no preclusion.
So yeah, move.
Item number 2 to be mentioned, W950/2021.
But before taking up this matter, my sincere apologies to my Honorable Chief Justice and Justice Rath. I was informed that it was in special mention yesterday. I was not aware, so I could not assist.
It is not with you. Problem is the counsel with the respondent, Mr. Linka, Dr. Linka.
Where is Mr. Linka?
I'm H.B. Das, my lord. So legal aid, my lord, direction was made, my lord, to apply copy to the legal aid service, my lord. Yes, has been engaged, my lord. My name is reflected outside.
That's all right. There is a letter because we marked the matter CAV after complete hearing.
So you want to submit today? You want to make submission today? As per instructions of the wife of the
My lord, I must know, my lord, what is the allegation made, my lord.
All right, show from the record. Allegations made that you did not raise the relevant questions. A written letter has been directly addressed to the.
Yeah, placed all points, my lord. But he wanted to say, my lord, he was present also, very day also he was present. He wanted to say from document that is evidence, my lord, that the process adopted by the office, my lord. He wanted to say that, my lord. I say, my lord, that is already, my lord,
Pointed out.
And the technicality is that the date was fixed for giving reply on 14/5/2009, sorry, 14/5/1999, but the order was passed on 6/5/99.
that we have.
And on that basis, the Honorable Single Judge had disposed of that case, my lord. That is
I think, Mr. We should fix a date
my lord.
and ask your client to come.
Yes, my lord. I would also
Certainly don't take the unnecessary responsibility on your
my lord,
shoulder.
I tried my best to contact today also, but he did not, phone did not, my lord, reach, my lord. That is why, my lord, in his presence, that should be done, my lord.
That is what I'm
Yes, my
telling you. We are
lord. Yes,
fixing
my
a
lord.
date.
My lord, may I?
Mr. I understand your embarrassment because you have argued at full. Because sometimes it happens for someone because it is about court, we understand and we know how to address it. But about a counsel who has done sincerely the best.
And I placed also the judgment said, my lord.
I think state your
But my
letter.
friend, see, the delayed court rely करते हैं जो submit the full copy.
The Lordship will appreciate before the single judge, the bank was unrepresented. So whatever documents are filed in the appeal are this.
We recollect everything because the letter that is annoying us, we have listed the matter.
Is that letter, my lord, what his learned single judge found to in his favor? One, that he had not received the inquiry report, that's why the punishment is initiated. Secondly, on the date fixed before that, he has passed the order. So my reply was that in his petition at page 55, he has received the inquiry report before imposition of punishment. And on the other side, that's given a judgment as a lordship had pointed out that in the list of petitions, the document futility, what would have made a material difference if you would have received.
Is that you have taken note of?
Your lordship
Fixing a date. There's a question of someone's confidence in the law here.
My lord.
Mr. That you just see this, it will be on record now. he will be in an embarrassing situation.
No, my lord, I bow down, my lord. I have no issue with that.
On the very day, my lord.
9th or 12th.
Any date, my lord, your worship, because
Because you have to communicate to your client.
because my lord, his phone, he does not receive my lord phone, my lord.
No, so let it be 12th, you sent a registered letter, so otherwise you will again
Yes, my lord.
send a letter.
True, sir.
This, in view of the letter received by the, received by the Registrar General of this court, written by the respondent. Where it has been stated that stated that the some vital important points could not be, was not raised by the council. Who has been representing her despite their request. We do not attach any importance to this imputation as Mr. S.B. Dash, Learned Counsel, has made all points probably could be argued in this matter. So, however, we direct the respondent, Srimati Kobita Sahu, no?
A respondent, my lord, Jajana Kazau.
My lord,
Who has written the
respondent is allowed, my lord.
Wife.
It seems, my lord, what I heard.
Only wife must have written.
Wife is not a party in this case.
He is not in a position to come, my lord, the respondent.
all right.
His son and wife are coming.
All right, just to wait. It has been informed by Mr. Das and Council that respondent is not in a position to come to the court. As such, we direct the respondents to someone after due instructions to be present in the court proceeding and to give the necessary instruction in writing to Mr. Das
Yes.
before he makes the fresh submission. Mr. And counsel is declared for the appellant.
Well, not 10. That is fixed to 12.
12th October.
Obliged.
Item number 3.
Item number 3. I am for the petitioner. I know that. I have some preliminary objection. If your worship will permit me, I can raise that objection. And practically, the prayer made in the writ application already addressed by the management of the Puri. Let me submit, my lord. Preliminary objection. This is objection. Let me submit. They want that this Ratnamandar should not be opened. Consider first. This is if I want to insist that they don't want to temple. This reality shows that this
Yes, Lucas will consider. Yes, will request Mr. Acharya to address that the issue of the locus.
let us first. Yes. Let it matter. Because we have the preliminary objection, we have raised the question of locus,
Yes.
and the locus obviously, see, he is the petitioner. So since we have raised the question of locus standard, so far as I know that I should don't know who can then have the locus. I think the temple administrator has the locus. Let me address me.
Now, I have a question to both the senior counsel.
Sir.
In a public interest litigation, how far the locus is material at all?
What you demonstrate for your lordship
let me also look to paragraph 5. The case about you also have heard at the admission stage, they have filed the affidavit So far the management is concerned. And try to insist. We also look to paragraph 5.
Yes.
Paragraph 5 of my previous objection. Humbly submitted. This is not the way we are doing that. May I submit my
Yes, sir. Yes, Mr. Acharya, you please, this will go to you only.
Sir, page 2, paragraph 5. It is submitted that the installed PIL has been prepared by Samir Mahanti, who happens to be a
Paragraph 5 of the petition.
preliminary object counter.
Okay.
Preliminary counter filed by OP number 6, management of temple administration.
Yes, yes. Yes,
Let's get it. Kindly come to paragraph 5.
yes.
It is submitted that installed PIL has been prepared by one Samir Mahanti, who happens to be an active political member of Bharatiya Janata Party (BJP), which is opposition political party in the state of Orissa. The petitioner had contested in 2009 assembly election on a BJP ticket from Ekamra Bhubaneswar Assembly constituency, which he had lost. From 2016 to 2020, the petitioner served as the state vice president of BJP, and from January 2020 till March 2023, he was made the state president of the party. Thereafter, from 13/7/2023, the petitioner has been made the special invited member of the BJP National Executive Committee. Then kindly come to para 7.
I didn't receive the copy of the same. What my learned senior is reading, they didn't serve the copy of the same.
This was served. This has been served. This is
Mr. Party, are you a petitioner or opposite party?
I will note their objection. Very good. I'm providing them some time. After that, I will come to you. I will also hear you on merit.
Sir, paragraph 7.
Yes.
It is a fact that the petitioner has time and again politicalized the Ratnabhandar issue by speaking in the media, using the forum of the BJP, even before and right after instituting the caption petition, this writ petition. The petitioner has conducted a press conference at the state party office of the BJP and has left no stone unturned to entirely politicalize the Ratnabhandar issue to gain political advances. Then we also kindly come to paragraph 8. It is pertinent to mention here that on 5/7/2023, the petitioner has ensured media presence in the court premises, and right after the hearing had gone ahead to give media bites exaggerating the issue, narrating about the court proceeding, and also leveling baseless allegations. Then para 9. These interviews of the petitioner, including the interview conducted on 5/7/2023, have been given wide publicity by patronage media houses across all platforms, including but not limited to TV broadcasting, print media, and social media. The transcripts of the media interviews bites given by the petitioner shall be needed or directed to place before this honorable court for time perusal. Then para 13.
How these are related to the scandal?
Sir, kindly come to judge. We also see this. Sir, I've got a
Signing judgment.
Yes, sir. Only I'll take 5 minutes, sir.
All right.
The first judgment I'll show you, Lordships. You also kindly come to
Given the reference to
yes, sir. I put a copy there.
petitioner. But I request to be very brief.
Sir, exactly. I know that at least this court I know, and today also I'm conscious that it's very, very limited, within 5 minutes. We also come to page Janata Dal versus H.S. Chaudhary, 1992, 4 SCC, page 305. We also come to straightway page 44. Page 44.
Yes.
Let's get it.
Yes.
109, para 109. It is thus clear that only a person acting bona fide and having sufficient interest in the proceeding of PI will alone have a locus standi and can approach the court to wipe out the tears of the poor and needy suffering from violation of their fundamental rights, but not a person for personal gain or private profit or political motive or any oblique consideration. Similarly, a vexatious petition under the color of PIL brought before the court for vindicating any personal demands deserves rejection at the threshold. The next judgment will also kindly come to page 92. That is reported in 2006, volume 6, SCC page 613. State will also kindly come to page 92.
Page 92.
Yes, sir. Para 58 of the 2006 SCC. In our opinion, public interest litigation is meant for the benefit of the lost and lonely, and it is meant for the benefit of those whose socially backwardness is the reason for no access to the court. We also say that PILs are not meant to advance the political gain and also settle their sources under the guise of public interest litigation and to fight a legal battle. In our opinion, that's what skip over. The next judgment is that is 2005 1 SCC page 590. Plus state will come to page 111, para 4, page 111. Para 4. Wait, sorry, 111. Let's get it. This is 2005 1 SCC page 590. Para 4 and para 12. Para 4. When there is a material to show that a petition styled as a public interest litigation is nothing but a camouflage to foster personal disputes, the said petition is to be thrown out. Before we grapple with the issue involved in the present case, we feel it necessary to consider the issue regarding the public interest aspect. Public interest litigation, which has now come to occupy an important field in the administration of law, should not be publicity interest litigation, or private interest litigation, or political interest litigation, or the latest claim, page income litigation. The High Court has found that the case at hand belongs to this last category. If not, so then state will come to paragraph 12. That is at page 114. Paragraph 12. Public, that's a good thing.
Yes.
Public interest litigation is a weapon which has to be used with great care and circumspection, and the judiciary has to be extremely careful to see that behind the beautiful veil of public interest and ugly private malice, vested interest and or publicly seeking is not lurking. It is to be used as an effective weapon in the armory of law for delivering social justice to citizens. The attractive brand name of public interest litigation should not be used for suspicious products of mischief. It should be aimed at redressal of genuine public wrong or public injury, and not to be publicly oriented or founded on the personal vendetta. As indicated above, court must be careful to see that a body of person or members of the public who approaches the court is acting bona fide and not for personal gain or private motive or political motivation or other oblique consideration. The court must not allow its process to be abused for oblique consideration by masked phantoms who monitors at the times from behind. Some persons with vested interest indulge in the pastime of the meddling with judicial process, either by force or habit or from improper motives, and try to bargain for good deal as well as they enrich themselves. Often they are acted a desire to win notoriety or chief popularity. The petitioner of such busybodies deserves to be thrown out by rejection at the threshold and in appropriate cases with exemplary cost. The next judgment here also kindly come to page 125. That is Ashok Kumar Pandey respective state of West Bengal, 2004 SCC, page 349, page 125.
Yes.
Yes, go. Para 12. Let's get to 125 paragraphs.
Yes.
Public interest litigation is a weapon which has to be used with a great care and circumspection, and the judiciary has to be extremely careful to see that behind the beautiful veil of public interest and ugly private malice, vested interest and publicly seeking is not lurking. It is to be used and effective, same language as we use. And if you also will turn to just 4-5 line button, as indicated above, the court must be careful to see that a body or persons or a member of the public who approaches the court is acting bona fide and not for personal gain or private motive or political motivation or other oblique consideration. The court must not allow its process to be abused for oblique consideration. Some person with vested interest indulge in the pastime of meddling with judicial process, either by force or habit or from improper motives. Upon they are acquitted by desire to win the notary. Also, skip over the last judgment I showed you, that page 132 at paragraph 2, page 132, very small judgment, 132. Uh, 2005-11 SCC page 507, para 2. Before us, it has been contended 132 years.
Is good.
Before us, it has been contended by one counsel for the first respondent that public interest litigation petition has been filed against the first respondent to settle personal score. The appellant does not dispute that he confessed against the first respondent from the same constituency. With this background, we are also of the view that public interest litigation petition has been filed by a political rival to achieve personal score. On this sole ground, we are of the opinion that petition cannot be maintained in the form of a public interest litigation, as it cannot be said to have been filed by the public spirited person. In this view, the appellant has no locus standi to file the petition as a public spirited person. Now, you also kindly look to the prior portion of the writ application. Well, I have said
No decision you are going to rely.
well, all the judgments are referring to paragraph 5 and 6 and paragraph 7, where he is a political person of a particular political party, and he had contested election, and he had made some the press conference in the party office for this particular case, and he has filed particularly this Jagannath temple and particular issue involved in the writ application. Therefore, he is directly interested. So he, at his instance, the writ he has no locus standi to maintain the writ application. Now, also look to the prayer. Just for a moment. Because I have submitted with your worship, we have already addressed this prayer by virtue of a resolution of the managing committee. I'll just show you worship. But let's kindly come to page 35 of the writ application. Supreme Court order. Does you get it?
Yes.
Why the opposite party shall not be directed to constitute a high power committee under the chairmanship of His Excellency the Governor of Orissa or a sitting judge of the Honorable High Court to supervise preparation of an inventory of the ornaments and jewelries of Lord Sri Jagannath kept in the seat Ratnabhanda. Pause for a moment.
Yes.
So, for an inventory of the ornaments and jewelry of Lord Jagannath kept in Ratnabhanda. This is the first prayer. The second prayer also will come B. Why the opposite party shall not be directed to open the Ratnabhanda for taking of the repairing and construction of the inner wall as per the letter of Archaeological Survey of India and recommendation of the technical committee contained as annexure 5 and 6. So the second prayer relates to the same Ratnabhanda, but is for taking of the repairing and construction of the inner wall.
That is not related to you.
So that is related to me. I'll show you.
No, Ratnabhanda, you have the right over the Ratnabhanda, but the repair work will be taken by the.
So that is also only after I open. Only after I open that will be. I
understand.
Now you ask me C and the C also I look to see why the opposite part number 7 shall not be directed to take immediate step for preservation of repairing maintenance of Ratnabhanda. Did you get it? Now you also look at our decision which we have taken. Give the activity. Copy over there.
Everybody will be copy. Yesterday they were putting that affidavit, my lord, that they didn't file it in the court. Just when the matter is being taken out, they are just finding it.
Please could have got so I have made the translation. I have made the translation that you also straight will come to page 34. Page 34. This is the decision which was taken on 4th August 2023. Page 34. Let's get it.
Yes.
So page 34 also see that who are the persons who are present. Gajapati Maharaj, who is the chairman, ex officio chairman, then your respect collector, superintendent, then your respect kindly come to serial number 5, Dr. D.B. Gadnaik, superintending archaeologist, Archaeological Survey of India. Then other members are there. Now your respect kindly, I'm just reading, the sitting as so and so, let's skip over, come to the next page. Any other matter, the permission of the chair. 1. Discussion on opening of Ratna Bhandar. The latter furnished by Archaeological Survey of India in the year 2018 and 2022. I'll place that one, if you permit me. With regard to opening of Ratna Bhandar to assess its structural status as per the direction of the Honorable High Court of Orissa, we have read out and discussed the meeting. Both the inner and outer Ratna Bhandar are joining to Jagamohan. The rituals of the lords are performed in the Lord Jagamohan, where the devotees also have darshan. The committee observed that repairs should be taken up at such a time so that both the rituals of Lord and public darshan are not to be obstructed. Both the ritual and darshan by the devotees would be seriously affected if the ASI team enters the Ratna Bhandar now to take up the repair of its inner person after assessing the status of Ratna Bhandar. Dr. Gadnaik, superintending so-and-so ASI, said that the status of the inner person of Bhandar could also be assessed through conduct of laser scanning from outside of the Ratna Bhandar, and the repair could be taken up by opening the inner Bhandar during Rath Yatra next year after making assessment of the inner status. The committee accepted the proposal of Dr. So-and-so with the advice that the ASI would constitute a technical team consisting of technical members nominated by ASI, including 2 temple surveyors and 2 technical experts, so-and-so in chief work department and so-and-so, as member to conduct the above said work. The superintendent archaeologist, however, informed that the necessary machinery for conducting laser scanning has presently been put to service at Ganavapi Temple, Bangladesh, from where it could be mobilized to Puri for making necessary assessment of Ratna Bhandar from outside only after completion of the work of Bangladesh. Since no inventory of the ornaments stored in the Ratna Bhandar has been made for many years, it is therefore necessary to conduct an inventory of all the ornaments of Lord stored both in inner and outer Ratna Bhandar during opening of inner Bhandar. The committee passed a resolution requesting the state government to constitute, because it requires under the rules. The committee passed a resolution requesting the state government to constitute a high-level committee under the chairmanship of a retired judge, either of the High Court or Supreme Court, to supervise the conduct of inventory as well as to determine the modus operandi. The committee also passed a resolution to send all the aforesaid proposals to the state government for approval and issuing necessary guidelines. So this is the decision which was taken. Now at this juncture, you expect time to look
going on merit.
No, not merit. This is you got to also understand that. You also look to the judgment. The Supreme Court what left. Also look to the judgment.
I think we will finish this case. So that is the whole importance.
Also look wanted judgment in that Madam Padi's case is whole
just begin first and argue the whole case.
Just
judgment.
So what is PIL? Scope of PIL?
Address a particular problem.
If
That problem is being addressed.
this kind of disturbance indicates that they are not in favor of
judgment. First paragraph. I think you had a question of argument.
Of course, it is my right. I am forgetting.
Let them say. Please, 5 minutes to complete.
5 minutes, sir. Because when many times address is necessary, the petition has been filed under Article 32 of the Constitution of India to direct an investigation, public inquiry into the disappearance of the key to Ratna Bhandar of Sri Jagannath Temple, Puri. It has also been prayed. Next, the prayer is important because that key issue is no more there because that was available immediately thereafter after Puri. Prayed that the inventory of the valuables stored at the Ratna Bhandar of Sri Jagannath Temple, Puri, be taken and to direct appointment of an expert committee to submit a report to this court for preservation and management of the property and valuable of Sri Jagannath Temple, where has also been made to provide express darshan. That's why skip over because I don't want to take your only also kindly come to paragraph 40. 40, right, 40. Paragraph 40, page 32 of that. Let's get it, paragraph 40. But this is not the final judgment. This is the judgment which has been reported and certain direction was made. Paragraph 40. It is apparent that various aspects have to be gone into and considered by the temple managing committee. And wherever the government role comes in, the government has to do the needful after taking all the stakeholders into confidence. Let the following aspect be considered. Then you also kindly come to last portion of that order. Para 40, para 40.17. Para 40.17. I was reading para 40. Let's come to para 40.17. With respect to valuable of the temple.
Yes.
With respect to the valuables of the temple, let the temple management place before this court what kind of inventory it has prepared, how it is proposed to secure the valuables of the temple and ornaments offered by the devotees, question mark. Then also kindly come to the last question of that order, para 42. Let the temple management committee consider various other positive aspects for improvement and invite all the stakeholders.
From where? Last
para 42, last but one.
Okay.
Last para is 43, is this matter on such as para 42. I think both of you are also get it, para 42. Let's start from let. Let the temple management committee consider various other positive aspects for improvement and invite all the stakeholders, including the state government, whose cooperation is necessary in permissible matters, to take care of financing the various development activities. The temple management committee has to take steps as it is the sole repository of the faith. The progress report and the decision taken shall be submitted in this court within 8 weeks in the form of an interim action taken report. Now, action taken report was submitted. The final order, respect I see, that is the final order. The honorable appeals court is compliance. This copy. This was on, let's see, on 8/5/2023. Very important, the date I am giving. 8/5/23 also, after the report was submitted on behalf of the state, action taken by the state government, the action taken report, that is designed as the action taken report. Considering that, what the honorable appeals court said, having gone through the compliance affidavit, does you get it? Filed on behalf of Sri Jagannath Temple Managing Committee in compliance of the judgment and order dated 4/11/2009, just now I read that order, passed by this court in Milani Pari and versus Union of India others, reported in 2019, volume 18 SCC 1. We closed the present proceeding, but that report, which I've just now read, that has been reported in 2019. However, it is observed that if anybody is of the opinion, oblique view, that any of the directions issued by this court in Madam Pari's supra are not complied with in its letter and spirit, it will be open to find an appropriate application, pointing out the specific non-compliance. And as and when such application is are filed, the same shall be considered in accordance with law and in the light of the direction issued by this court. This order was passed on 8/5/2020, also kindly mark it. And the next line is, however, it is clarified that such an application should be filed made before the High Court, and High Court shall monitor the implementation of the direction issued by this court in Paris Supra. We appreciate that also. So we also look that this order was passed on 8/5/2023, and the present which application has been filed just 1.5 months after, 1.5 months after by the present petitioners. And usually after filing the writ application, the management has taken a decision, has already addressed the prayer made by the petitioner in the writ application. That means one is Ratna Bhandar inventory, the second one is repair. The only question now left that when it will be done. And the rule provides, the Jagannath Temple rules provides that under any circumstances,
My lord, I think he has finished his part.
All right.
I don't think.
That's it. So rule provides that when one likes, itself on this account. That means for inventory, the performance of the sebas and nitis of the temple are interrupted or in any manner prejudiced. It's also look to that paragraph, page 34.
Rule, you are referring to rule?
Rule 5. Jagannath Temple rules. This is Jagannath Temple rules made pursuant to section 32 of the Jagannath Temple Act. That rule 5, if you actually look to 5, procedure for taking over possession.
Okay.
If the last line of that main paragraph, you also see that Dr. Mandar's that stock that has been classified within 3 categories. First category is never used, ornaments which are never used. The second category are used only for ceremonial or festival occasion. And the third one is those are daily use. People also, yes, that is rule 6. But you also look to sub-rule 5.
Yes.
During the course of the proceeding, the issue and redeposit of the jewelries, as many as may be necessary for the due performance of the Seva shall be made in presence of the person specified in sub-rule 2. If any event, the proceeding cannot be completed at one sitting, the jewelry shall remain under the seals of the district magistrate Puri, the committee and the Raja of Puri, provided that it shall be the duty of the committee to ensure that on no account, the performance of the sebas and nitis of the temple are interrupted or in any manner prejudicial. Then provided further that no event shall any jewelry be removed beyond the so-and-so, that's we are not concerned. And 6 is the custody of articles. So for the management is concerned, like Lordship was asking me, you also come to section rule 6, custody of the article. The first category, this is coming under first category. The inner documents, that jewelry that comes under first category of articles specified in rule 5 shall remain under double mark and seal with the seal of the committee, the managing committee, that committee which was constituted in terms of the rule. The keys being deposited by the administrator in the government treasury. The locks may be opened only under special order of the state government and subject to such condition and limitation as the state government made by special order direct. Let my non friend argue, if necessary, so for this
one line I'll supplement to the question of notice handling. Just bring to your lordship's notice that there is a WPC TIL 9098 of 2016 by one Abhishek Das on the self-same issue, of which your lordships are already in session of, and a slew of orders have been passed.
16, the keys were not lost. Let me submit. They will not say that time. So that has no connection. That is what completely that matter is still this not the way.
WBC number?
WPC number 9098 of 2016.
2016.
16.
Always.
Abhishek Das, so that is one issue. That it is also the rules of PIL that multiple applications on the self-same issue should not be entertained so as to engage the court in unnecessary.
Rule 8 you also referred to. We have referred to that in your objection. Rule 8 says that it's mandatory. If a person wants to invoke the power under public interest litigation, he has to make a representation to the authority, which he has not made. Admitted.
What has been recited in the writ petition is that there is urgency, so the rule is being waived. But what is that urgency? It is not borne out from any of the reports of the ASI. That there is an urgent requirement to address this.
Urgency is a very subjective method to achieve.
May I begin, Miller? I think the other side had. We had 3 aspects. Well, let us first understand they filed this petition. They contended that because he is a political person and was the president of state BJP, so he is not somebody, nor a Jagannath devotee. His rights are in no way affected. I'll answer that. But Jagannath Mandir Temple Administration, Milord, if I go to the background, in 1952, Milord, the state of Orissa decided to take over the management of Sri Jagannath Temple Administration and its endowments and enacted a legislation. That is Jagannath Temple Administration Act 1952. 54 Act is a subsequent act. But under the 52 Act, an officer, judicial officer in the rank of district judge, Sri Lakshman Pandya, he was appointed as the special officer to make the inventory and also to codify the different kind of Seva Puja rituals, the Raja's duty, the Seba's duty, etc., which is called popularly known as record of rights. That is extinct from the market because it was gazetted. Recently, we are taking a step to publish that in the form of a book around running 1500 pages. It is underway. So, your Lordship may kindly turn to first 1952 Act. Why am I here? 52 Act, your Lordship is there, the Temple Act. Your Lordship may kindly Puri Sri Jagannath Temple Administration Act 1952. By virtue of this, 1952, I'll come to 55 Act. Your Lordship may kindly see the 1952 Act first.
Page 72, that is.
Yes, I am arguing. I can show. There should not be any inter-se argument. Page 69 in my book, maybe 72 in that book. Puri Sri Jagannath Temple Administration Act 1952. This is mirrored in the preamble. The object of the legislation was an act to provide for the administration of Puri Sri Jagannath Temple, preventing mismanagement of the temple and its endowments by consolidation of the rights and duties of sevaks, pujaris, and such other persons connected with the Seva Puja and management thereof. This is the objective behind this legislation. This definition chapter that came into force immediately on the state government notification appointing this behalf. The notification was made on 5/9/52 in the extraordinary Orissa Gazette.
All right.
Your definition chapter, what is endowment, prescribes specific, that is
not relevant.
Your Lordship may kindly come to
Just on 2 points.
2 points.
First of the repair of the Ratna Bhandar. I think this has become very vulnerable.
That's correct.
Protective action by way of repair is required to be taken. This is number one. And to make the inventory. And to tally the earlier inventory.
Lordship is absolutely right. I will address on these 2 points.
Yes.
Your Lordship may now kindly come to one rule. Let me show how it is to be kept. The inventory. Your Lordship may kindly turn to Section 15 of the Act. Section 15 of the Act. The duties of the committee of the Temple Act 1955, the second act. Subject to the provisions of this act, Section 15.
Yes.
Subject to the duties of the committee, subject to the provisions of this act, and the rules made thereunder, it shall be the duty of the committee, 1, to arrange for the proper performance and Seva Puja and the daily and periodical nitis of the temple in accordance with the record of rights. Record of rights have been prepared under 52 Act. To provide facilities for the proper performance of worship by the pilgrims. 3 is important we are concerned. To ensure the safe custody of the funds, valuable securities and jewelries, and for the preservation and management of the properties vested in the temple. This is the bounden duty of the temple administration, which has been created under Section 16. That the committee, under Section 15. The committee is under 6. Section 6. Your Lordship may kindly turn to 5 and 6.
Committee.
No, constitution of the committee.
That is the formation of the committee.
That's correct. So permission of the constitution of the committee, who shall be the members?
Yes.
Committee under the constituted under Section 5. Section 5 is also important. If your Lordship would permit me and read only 3-4 lines. Notwithstanding anything in any other law for the time being in force, or custom, usage or contract, sanad, deed or engagement, the administration and the governance of the temple and its endowments shall vest in a committee called Sri Jagannath Temple Managing Committee, constituted by as such by the state government, and it shall have the rights and privileges in respect thereof as provided in section 33. It shall be a body corporate having perpetual succession and a common seal, and may be the said name Sue and Sue, constitution of the committee. The committee constituted under section 5 shall consist of 12 members and shall be composed of as follows. The Raja of Puri, who shall be the chairman, an officer not below the rank of additional chief secretary, ex officio member, who shall be the working chairman, the chief administrator appointed under subsection 1 of section 19, ex officio member, who shall be the secretary, collector district of the district of Puri and ex officio member, the commissioner of endowments, the additional secretary law, superintendent of police, the superintending archaeologist or archaeological survey of India. We had one person to be nominated by the state government from among the persons entitled to sit on the Mukti Mandap, 5 persons to be nominated by the state government from among the sevaks of the temple, 1 person representing the mosques and other institutions connected with the Seva Puja or duties of the temple, or any Hindu religious spiritual organization to be nominated by the state government member. 3 persons, one of whom shall be chartered accountant, from among the persons who do not belong to any of the categories referred to in clauses J and K as members. We have provided that this is the constitution of the committee. Let's now kindly come to rule Mila. This is very important. 1960 rule. First, this administrator was appointed under 52 Act. He made an inventory, prepared the record of right, and followed by that, this taking over, handing over of possession took over as per the 1960 rules. You will also kindly turn to Rule 5. Procedure for taking over possession. The committee immediately on its first assuming office shall, in the manner hereinafter provided, take over charge of all gold, silver, precious stones, and other jewelries inside the Ratna Bhandar from the Raja of Puri, after actual verification of the stock, which shall be classified and dealt with 3 categories, namely articles that are never used, those that are used only on ceremonial or festive occasions, and those that are of daily use. We have 3 categories. We are now concerned with the first category. The following persons shall be present at such certification. The committee represented by at least 2 of the members of the committee other than the administrator and Raja of Puri, the administrator, the Raja of Puri or its representative authorized in writing in that behalf, the Hindu religion, failing which 2 officers in the active service specially appointed by the government in that behalf, provided that such district magistrate or such superintendent of police, if he is unable to be personally present at such verification or at any time during the course thereof, shall have the power to depute to act on his behalf and subject to his control an officer not below the rank of a deputy magistrate or a deputy superintendent of police, as the case may be, and the expert, if any, professing the Hindu religion, as the committee may deem fit necessary to appoint for assigning the testing and identification of the jewelries. After verification of 3 separate inventories, showing the full particulars of each of the 3 categories of articles shall be drawn up by the administrator and attested by the persons enumerated in Sub-Rule 2 and present at the verification. The verifications, if any, noticed from the list of jewelries acknowledged by the Raja of Puri in 1926 and preserved in the record.
This is the statute has laid down certain procedures.
Exhaustive procedure.
So the only question when this inventorization will take place, then persons who has taken decision, they are to strictly follow all these procedures.
That's correct. No debate on that issue. No. There one thing, Rule 6, Rule 6. This is very important. I will only place Rule 6. The first category of articles specified in Rule 5, this only Rule 6, Rule 6 is important. So therefore I am reading. This is important. The case will rest on this. The first category of articles specified in Rule 5 shall remain under double lock. This is very important. Under double lock and sealed with the seal of the committee, the keys being deposited by the administrator in the government treasury. The locks may be opened only under special orders of the state government and subject to such conditions and limitations as the state government may by special order direct. Your Lordship was asking this, and to file a specific affidavit by the temple administration, if any such request was made to the state government between 2018 till date, in view of the matter that the keys were missing, the original keys which were supposed to be kept in the government treasury under double lock with the seal and signature of the temple committee members, that was missing from this treasury. So for that they had set up a commission. Nothing happened to that commission's report, not a table in the house, Ravi Vidya's commission. So rule 2, sub-rule 2. The second, subsequently, Milord, when there was agitation throughout the state because the sentiments of people is involved due to Lord Jagannath, so Milord, they showed a duplicate key. Milord, for the duplicate key of the original, whether that is the real duplicate key of the original by which the locks can be opened, or they manufactured some key just to pacify the public resentment. That is another aspect. That's a big story.
So that is why you have asked for this inventarization of the whatever the articles are available in the Ratna Bhandar.
That's correct. That is very important.
That is also that's there.
So therefore, my lord, if the keys are available and there has been no inventory since 1978, my lord, 45 years almost, and the suspicion is bound to be not the minds of the people because the duplicate, the original key was missing from the treasury. There might have been some hanky-panky. So government,
on the basis of a surmise, no court will like to proceed.
It is not surmise, my lord. They say it is
a presumption doing.
No, they have said it in the counter. They have said in the counter.
Regarding the key.
Key, they have said a duplicate key is available. So, no, your lordship, government, please, government.
No duplicate. We have never said duplicate.
So what is that? Original?
Yes.
This is very strange to make such a patently false statement in the court. The collector himself held a press meet and said that a duplicate key is available from the record. Please don't interrupt like this. You are a senior counsel. Please.
Yes, I know.
The collector, my lord, after 2 months, when there was mass movement in the state regarding this key, this is not surmise. They have said here, my lord. You will also kindly turn to page 4 and paragraph 14 of their counter. Temple counter preliminary affidavit. And 15, page 4.
Yes.
Well, page 14, may I read it, Miller? By way of order dated 5/7/23, the opposite party number 6 has been directed by this honorable court to clearly state, that is your lordship's order, in the affidavit as to whether it had approached the state government seeking permission for opening of Ratna Bhandar anytime in the context of missing of the keys of the Ratna Bhandar of Lord Jagannath Temple. Para 15. In this regard, it is submitted that SJTA, Sri Jagannath Temple Administration, Milord, has not approached the state government for permission to open the inner Ratna Bhandar in context of missing keys. However, the SJTA had intimated the state government regarding unavailability of the keys of the inner Ratna Bhandar. So it is not my surmise.
Next para.
The temple administrator, I know which para is to be read, Mr. Rautray. Please don't prompt. I know you are a very erudite and skilled lawyer, but please don't advise me.
Yes.
I will take your advice outside the court, not here.
Duplicate.
Duplicate kya? What is the meaning of the missing keys means what? If you are
There's a they have
that is a duplicate key. What is that? Then you find an affidavit that's the original key. If that is so, that you find an affidavit that the keys which were found is including the state laws. For last 5 years, this drama is going on.
That we have already noted your
yes, keys are admittedly missing. 17 people went to open Ratna Bhandar as per the direction of this honorable court for repairing of the Ratna Bhandar. They did not open it. Came back. The then chief administrator, who is the chief secretary now, he announced that the keys are missing. The collector held a press meet in Puri and said that no, keys are missing. After 2 months, suddenly, without like democracy in Pakistan, it appeared, and they said, gave this name that a duplicate key was found from the record room. This is how the story is. It is not story.
Don't bring a foreign country's name in the proceeding.
No, that is that.
This is not a political platform.
No, I'm not willing to say that is the policy. No, is correct.
You want to be way of the foreign entry. You this kind of conversation process.
The strange appearance. It's a simile I gave, not to, I don't have any English against any country.
So don't do that.
Yes, I'm sorry.
Don't embarrass us this
No,
way.
I'm sorry. So what happened, these duplicate keys were found from the record room instead from the government treasury. And the last inventory, Milord, I have given the report in the writ petition. If you also could have a permit me, the report is at page 1, page 39, Milord. Page 39 of the brief. Let's kindly look at this. It's very strange. Page 39, Milord, the then government, 1978, let's kindly. Sri Jagannath Temple Administration Improvement Committee report of page 39, Mila.
Yes.
So your Lordship may kindly look at who made the inventory in 1978. Sri B.D. Sharma, Governor of Odisha. Sri Dibya Singh Dev Raja Puri, the present Raja Mila. Dr. Harikrishna Mahtab, he was the Chief Secretary of the, Chief Minister of the state and the first Prime Minister. Sri Vishwanath Das, he was also the Chief Minister of the state. Sri Nityanand Kanungo, he was a governor of Maharashtra, I think, Nityanand Kanungo. Dr. Radhanath Rath, editor of Sambhag, a very, and he was also a minister in the state government. Sri Justice Sri Harihar Mahapatra, a retired judge of the Honorable Court. Sri Nandakishwar Mishra, Speaker Odisha Legislative Assembly, and Sri Aditya Das, who is a Mahant of MR Moth, I think.
Yes.
So these 9 persons, Milord, were appointed, made the inventory. Your Lordship would find it from page 97. Lordship may kindly come to this page 97. What are the jewelries that Milord, 78 is the last recorded available record so far the inventory is concerned. Milord, page 97, your Lordship may kindly turn to. Abstract of Sri Ratna Bhandar, category 1. We are concerned with inner Ratna Bhandar, category 1. Head ornaments, number of articles 97. Body is 802. That is around, Milord, 8 kg. Aega. This one, 802. So ear ornaments, nose ornaments, neck ornaments, arm ornaments, wrist ornaments, figure ornaments, waist ornaments, leg ornaments, miscellaneous. This is, Milord, total 367 gold and other precious stone articles. Milord, total bhari is 4,364 bhari, which may come to 43 kg. So, Milord, this silver, puja equipment, 93 items, utensils, 74 items, miscellaneous, so-and-so items, total is, my lord, 148 kg. These are the lists.
All right. This is status on the day, the report, whatever they see, this is the inventory that has been accepted by the committee, and also it is lying in the state government.
State government, Milord, with temple administration also.
Yes.
So this is the last inventory of 1978. Milord, 5 we are now.
I'm just failing to understand one thing. Because the temple administrative committee has come out with their resolution very categorically stated.
My lord.
We have no inhibition for preparation of the inventory.
That's correct.
But 2, that we have no inhibition for repairing of the Ratna Bhandar.
Right,
They have taken a
absolutely.
decision.
Absolutely.
And they have chosen a time because this is otherwise the devotees would.
No, that is the connection with the devotees. Milord. We want to, is telling me that it should not be political. We want this 24 election should be over the election in October next year. Right?
There's
No, your lordship may kindly come to ASI.
no, that is the, then obvious.
ASI.
You are trying to take in the political mileage.
Safety is in question now. ASI. Your lordship may kindly come to ASI.
I will not give a notice to the petitioner. So far the temple safety is concerned. Superintendent Archaeological Survey of India was his comments has been recorded in the resolution.
No, my lord, affidavit your lordship may kindly look at.
Today filed
No, it is filed long ago. Back.
This is the resolution of the administration committee.
Administration committee will
we cannot outsource certain matters to some other individuals. We come to the resolution. Superintendent Archaeological Survey.
Archaeological Survey of India, they are not taking them into confidence at all. They want to dominate the temple.
Come to this.
This letter of the superintendent to SI University, today's letter, kindly.
Today's letter.
Yes, today's letter, the 25th. 25th.
Yes.
Only 2 paragraphs. Mr. Padiwan said, let me read out only 2 paragraphs of ASI's counter affidavit. Please, your lordship may allow me to read it. Only 2 paragraphs I will read. That's kindly allow me.
There occasion file a counter affidavit.
Are you aware of this letter?
That letter was, I have given the copy, I am also serving the copy, the 2 sets of copy to the court, my lord.
It's all right. Have you served the copy?
Why I am giving the copy? This communication received from today, that's why I cannot read in the take this report in that I am filing the counter affidavit. But my sole submission to my lord is that paragraph 6 and 7 were elaborately explained all.
Yes.
Now question is coming that scanner and that scanner can be worked outside, not inside. If whatever scanning they have done, what I have discussed with the superintendent, he told me that scanner, what they have explained in the counter affidavit, particularly what we have mentioned.
6, 7 and 8, let me just place, I will be not stopping. Only 3 paragraphs, let me read out. Mr. Padi. Paragraph 6, it is only submitted. Your lordship will kindly turn to ASI affidavit. That is, 1 second. That it is only, let your lordship permit me, only 2 paragraphs I will read out. If your lordship would be satisfied with this. Paragraph, it is only submitted that the Archaeological Survey of India has constituted a technical expert committee for inspection of Ratnabhanda inside Sri Jagannath Temple via letter number 38 dated 10th April 2018 under the chairmanship of Professor G.C. Mitra, ex-secretary to Government of Orissa. The committee took up inspection of the Ratnabhanda on 26th March 2018 and 8th April 2018. The committee during the inspection found that the Ratnabhanda was constructed over the pista raised platform around the main temple. The data regarding its construction of inner dimensions are not available. However, it appears to be built around 13th to 14th century AD. It is integrally built along with the northern fascia of the Jagmohan Hall. It is a bland structure with white washing on the surface. However, the plaster seems to have become weak, and some places, as noticed from the hollow sound upon tapping the surface. The committee could examine only the exterior. It is submitted by the committee that final decision on the structural condition of Ratnabhanda can be taken up after the inspection of the interior. The committee may be allowed to enter inside. Now, this is important. May be allowed to enter inside and inspect the Ratnabhanda interior structural and archaeological details of Ratnabhanda under proper lighting system. The copy of the report of the technical expert committee inspected Ratnabhanda on 26th March 2018 and 4th April 2018 are enclosed here with marked as annexure B/7 series. Well, if you I'll take your just a minute. That is in paste, and I'll just show that. That it is para 7. Humbly submitted that the Archaeological Survey of India,
All right.
This affidavit, this Archaeological Survey of India not received any permission from Sri Jagannath Temple. Well, you lordship look at the non-cooperation. Well, you lordship to kindly see that the Archaeological Survey of India, counter. Yeah, lordship, he is passing over a counter affidavit. Your lordship will just read.
That's all right.
Yeah, I am reading it. It is audible. Archaeological Survey of India has not received any permission from Sri Jagannath Temple Administration, Puri, for inspection of Ratna Bhandar by the Technical Expert Committee from inside in order to assess as to whether the same requires maintenance, repairs or not, as directed by the Honorable High Court in its order dated 22nd March 2018 and 29th March 2018. This Honorable Court has earlier directed me to go and inspect. Next page, para 9. Only para 9 I am reading, that it is humbly submitted that keeping the safety, security and proper upkeep of the ancient monument in view, the Archaeological Survey of India could be able to assess the quantum of conservation work, repairs of work of inner Ratna Bhandar of Sri Jagannath Temple for the structural conservation, security and safety of the temple only after detailed inspection from inside of Ratna Bhandar by the technical committee. But what else would they write? They say that it is the safety of the temple is under threat. It will be done after 1 year. Well, suppose there is a hole in my house, in the roof of my house. Should I wait that let the rainy season be over? I'll do it. It will not cause any. They have gone, in fact, in April to open the door. On 4/4/2018, that report is there. Please, you are supposed to kindly look at that report. Okay. That report is there. You are supposed to kindly look at that report. At page B/7, page 10. To the Constitution of Technical Committee, so and so, with reference to your letter number so and so, dated 30th/4/2000, that is post below the order of this Honorable Court. On the subject cited above, I am directed to convey the approval of Director General SI for constitution of the following committee for inspection of Ratna Bhandar inside Jagmohan. Counter affidavit 10 page, ASI. Inside Jagmohan Temple, Puri. Professor, same names I have already read. I am not repeating. Your Lordship may kindly turn to the next page. Following the order of the Honorable High Court of Orissa, Technical Experts Committee was formed to inspect the Ratna Bhandar of Lord Jagannath Temple, Puri. Accordingly, the committee inspected the Ratna Bhandar from outside on 26/3/2018 afternoon. This is also known as Bhandar Ghar. It is constructed over the pista so and so around the main temple. The data regarding the construction of inner dimensions are not available. However, this appears to be built around 13th to 14th century. It is also called as Amuha Temple without any door for entry. It is integrally built along with the northern fascia of the Jagamohan wall. It is a blind structure with whitewashing on the surface. However, the plaster seems to have become weak at some places, as noticed from the hollow sound found on the tapping on the surface. The committee could examine only from the outside. The temple is approximately 40 feet high. It is submitted that a final decision on the structural condition of Ratna Bhandar can be taken only after the inspection from inside. Therefore, inspection of the expert committee may be allowed by entering inside and inspect the interior structural and archaeological details of Ratna Bhandar under proper lighting system. But they say that we want to inspect. This is the SI team. They have written letter to the state government how apathetic the government is. Let the next page. Annexure CY7. This is the latest letter. Page 16. Inspection of Ratna Bhandar. This is the Milord Superintendent rights. With reference to the subject mentioned above, this is to inform you that Honorable High Court of Orissa in its order dated 22nd March in WPC number 9098 of 2016, Abhishek Das, the read petition which they were referring to, there was an order, they flouted it, has directed that ASI may be allowed to inspect the Ratna Bhandar of Sri Jagannath Temple, Puri, to assess as to whether the same also requires maintenance, repair or not. The Honorable High Court further directed that the temple administration shall permit the ASI to inspect the Ratna Bhandar on 26th and 27th of March 2018 as may be convenient to both the temple administration and ASI. Accordingly, a committee has been constituted by the Director General ASI, guide letter number so and so. In this context, this is to inform you that the Technical Expert Committee inspected the Ratna Bhandar of Sri Jagannath Temple, Puri on 26th March 2018. As there was no permission to enter inside the Ratna Bhandar, the committee could examine only from the outside. However, committee observed that plaster seems to have become weak at some places, as noticed from the hollow sound on tapping on the surface. Therefore, it was decided that final decision on structural condition of Ratna Bhandar can be taken only after the inspection from inside. They repeatedly say this. 18 they say, 22 they have been following. The government is sitting below. But it is the urgent.
We all understand the necessity of the inspection.
That's correct.
So no, given the any final opinion, so we have to make a formal final opinion, we have to inspect.
Yes, that's correct.
That is the thing.
So let them go and inspect, let it be open. Let them inspect, the temple may collapse. It's a serious thing. They say that is.
Why you are getting this information?
They are saying that is threat to the safety and security. No, they say I read out.
The hollow sound and everything are there.
Let them go and inspect. What is the hard
will collapse on the basis of what?
No, they say there is I read out
repeatedly that it will collapse. Let us also understand.
That is a part, no. Temple, Milord, it is a separate, there is no inconvenience.
Important. Structure is important. How do you say that it will collapse?
Let them say, the expert committee can only say, Milord. They say that we want to inside.
That it will collapse.
No, collapse, exact word, Milord, I will not. The structure is in what? Collapse is very unfortunate. My Lord should not at least use unfortunate is concerned. I think collapsed. We are doing gross injustice to the temple and saying that collapse. Collapse is a very year word, Milord. It is a very not a strong word. Many things can be said. I know the sentiment of the people is in. Why do not they permit the ASI to enter inside? That is the other question. ASI says that we want to go inside to inspect. They say that no, we will not do it. Temples
where they have stated so that we will not allow the ASI to enter it.
Well, I read out that they are not allowing granting permission.
No, it is the ASI statement. Any communication?
Yes, no, ASI counter affidavit is. ASI communication I have enclosed. Affidavit today. This 20 16 they have written. But in view of the law, 1 second, you are requested to kindly make necessary arrangements for issuing permission for inspection of interior Ratna Bhandar of Sri Jagannath Temple Puri in order to comply with the directives of the High Court of Orissa in its order dated because they have written it here. And this is of August 2022, a year back. But page 16, I am reading the last paragraph.
Yes.
They have clearly written. It is now the body in the government court. They have to, they should permit the SI to go inside. They are preventing. This letter is clear that you allow us to go inside. We want to inspect. Why are you afraid,
inside letter, I have enclosed
6 technical people will go inside. So why should they object to? Paragraph 4. That is the question, that is the doubt.
Who are they? Who are they?
They means the government, state government and
it has nothing to do. That is also the request of the administrative committee.
The administrative committee has not issued the state government. We are the ASI government. ASI is the authority so far the maintenance of the temple is concerned.
Yes.
ASI has expressed deep concern that this is the thing since 2018. 2018, Lord, they have been pursuing with the government, with the administration that you kindly allow us to inspect so that we can assess the quantum of damage which might have caused, which requires repairing. Lord, what is the impediment for the government to open it? That is the question, Lord, which I have been asking myself 10 times a day, not getting an answer.
I am just clarifying, madam. Both the councils have completed their training, I think so.
One line I show. Kindly also look to page 4 of the lines. Paragraph 4 is aware of the opinion. That's ASI letter. The team are of the opinion that inside the Ratna Bhandar should again be examined during the Ratha when the laws are not damaged. That is what there is only a damage with the good damage should not further be decided to consider.
If there is any damage, they clearly show in the report the damage should be immediately controlled or repaired. Why after 1 year? So there should be some logic behind 1 year.
Logic is this, man. Logic is very
There is no logic. Logic is that thing that you
and you are
that one that no court can do anything. Yes, I cannot do anything.
Mr. Acharya, who will give a notice to the state government for opening the Ratna Bhandar?
We have returned the temple committee.
But according to the statute you have brought before our notice.
Yes, sir.
No, they have written below in the counter, my Mr. President, my friend, Rautra was reading that. So they have written to the government after 1 year. He was reading that Miller just now, affidavit.
No, rule 6.
Today, whoever may be, all are parties before the lordship. Government is party, temple administration is party, Orissa is party.
We have not issued any notice to the government as of now.
So let notice go to the government. Let them accept their all three present.
Because the office sitting there in every matter, we cannot send notice. So
that is why
where government has failed in their role.
Government has failed in their role because
How?
we have written letter,
But
we have written letter.
it should go from the administrative.
They say we have written. They say Mr. Rautra was arguing, we have already taken the decision to the government. But he has written it affidavit just now.
Need the copy of the affidavit also with you, Mr. Acharya.
Yes, you are reading that loudly, very loudly. We have written from
Even mildly, not loudly.
where the where is that cool letter? Cool letter. I think you affidavit. Cool letter. Where is it? This is in Oriya. You will have
No, I have given the translation in English. Last 2 pages, the translation.
Yes, page 35 they have written, the letters furnished by the Archaeological Survey of India in the year 2018 and 22. Just a minute.
Yes. Read.
2018 we wrote and 22 we wrote. 5 years.
Whom? My question is to whom?
To the temple administration. Because they have
Temple administration is not the government.
they will tell whom this 22 letter I am reading, it is chief administrator temple. 18 also we wrote the
These are
temple.
two separate
Temple is a government body, that is a government body.
No, that is it's a statutory body.
Statutory body is not formed by the law department of the government.
No, it's formed by the law department of the government as per the statute.
That's correct.
Provided.
Let me complete this, Milord. This,
But you have failed to show that any letter has been given from the administrative.
That is their failure, Milord. That is fine. Because they have failed, I have come for a management.
So
they are not writing
in the state government.
So that's fine, Milord. Madam, my purpose is not to raise anybody in this situation. My whole objective is that the temple should be protected, number one. The jewelry should be, inventory should be made.
And we are opposing it. They are not opposing it.
So that's, let that order be passed.
That they have taken the resolution.
No, next year, October. Damage cannot be next year. Why not next year? You can't. I can dictate who dictates then. I am not dictating, I am praying before my Lord. Dictating, I am not dictating. Maybe they are using some improper words. They want that it should come from my lips. I am not dictating.
Prompted.
No,
and you answered, who will dictate else me?
No, I prompting I hate. I don't like prompting. So whatever comes from here, that's the. So let this prompting part, I should not go in detail now. Prompting state government and Jagannath temple, they are prompting each other. To some extent, Pillar, they are prompting that no.
This is all the assumptions. Because of this reason, we refrain to issue any notice to the state government.
No,
because we did not feel any failure on the part of the state government.
Because state government can do it since 18. They have been writing. This is a failure of the temple administration. Your lordship is absolutely correct.
Is a failure of the temple.
Your lordship is absolutely correct. I bow down.
Right.
2018 is this over it.
No,
2022 year back.
Are you the member of this temple administration committee?
Me?
Huh? No, I think Archaeological Survey of India.
Yes.
Yes.
So
So we have been
we
writing.
have a platform to discuss about the thing here.
Right?
Because I saw the resolution, Mr. Sorry.
Resolution Archaeological Survey of India doesn't write.
That resolution concerned, I will take this. But today they have filed the affidavit.
Ah.
So I don't have that instruction as regard to that. Only I have received this copy. Basing on that resolution.
Because we don't assumption. Otherwise, first question and first I would have asked you.
Letter
that why this letter has been issued today itself when you know the matter.
That was 23.
Ah.
Then immediately settled, and that is one day before the ASI's affidavit. ASI has taken a very bold stand. ASI has been pursuing the matter since 2018.
Paragraph 8 of my affidavit, not see my for CNE for a moment. And whatever resolutions they have taken, as your laser scanning, what I have discussed over phone to the superintendent, he told that the laser scanner can act outside the
Outside, not from inside.
It cannot go enter inside the temple and assess the damage. So it's but it is coming with the temple admission. They have to give permission for the SI. Then only SI people can go inside the temple and assess all these temples.
Is it serious matter? It's a serious matter.
Mr. Pari, that I'm going to use that word from your mouth only, hide and seek. You are part of the Temple Administration Committee. You have took part in the proceeding.
Yes.
You are part of the resolution taken by the Temple Administration Committee. Now, I will not allow you to take a different stand here in the court.
My respectful submission is 2 days later, there is nothing.
Everything, every coordination.
2 days later,
yes, fall apart.
The ASI has some limited rule as regard to maintenance the temple is concerned.
But that his point is that ASI is not being allowed to take a role regarding the preservation of the. That is the point.
Is concerned, what I am saying, my lord, we are not going against the temple administration or anybody. May the stand of the petitioner may be one that's the opening of this Ratna Bhandara, or they may come forward this, we have taken all steps. We are not there. We are before this court, my lord, we are coming with a very clean hand.
Yes.
That we are ready and willing to assist in all manner.
No, that is reflected in the resolution.
As regard to inspection of Ratna Bhandara, as regard to maintenance of Ratna
Only on
Bhandara.
only on the other day, perhaps you are not there, someone, Mr. Gupta may be
Yes,
there.
yes, yes.
In the Natmundi's Mandap case,
Yes.
that we have directed the ASI that you are sleeping over the file. When a decision has been taken to just give the replacement pillar by the steel box pillar. No, we are talking to the IIT Chennai, Madras IIT. They have not sent the design, so we are sitting over.
So my lord may direct, my lord may direct and let the ASI inspect and let them assistance.
No, I am considering render as like 2 days later. Yes, I have to go there. If they don't permit the case, it is has been commanded under the present industry, Gajapati Maharaja, on 2023. It has been proposed in the meeting for inclusion of the members as 2 Sedayat from the temple side.
That is completely unrelated matter.
It is unrelated. Compliance with the resolution.
Yes.
That is not incorrect.
Your lordship may direct the ASI, let them go, they will render assistance. What if they have, they are not.
We have heard you pass the order later on, not in the court.
Right.
Okay.
My lord, can it be, may I pray, my lord? It's a question of sentiment of all over the country, my lord. Everybody is a devotee, including me, your lordship, everybody. My lord, we are not praying anything new. We are praying that let the temple in our Bhandar be repaired. They say that it is unsafe.
All right. I have taken note of this.
My lord. So if the temple administration and the government or ASI, whosoever, is derelict it, your lordship may direct. March 2018 also similar order was issued Only thing they said that the keys are not available. Now that the keys are available, if Mr. Rautrai says that is the original key, it is fine, your lordship may record it. So let them use that key and open it. A 5-6 member committee ASI can constitute technical committee and go inside.
Okay.
So let that is one part. Other part, inventory part, your lordship put here it, inventory part.
Yeah.
That's inventory. Let this inspection part, this repairing part be addressed by your lordship. That is why we are here.
All right.
That is deeply obliged, Pula.
My lord, using this order feature. Order feature.
Your lordship dictates order in the open court, that is correct. Your lordship usually dictates order in the open court. That's very pleasant. It's quite pleasurable to listen. Your lordship, yes.
Because we do not like to disturb our board, that is why we are taking.
As your lordship pleases.
Yes.
But I will remove that prayer. Let the SI be directed to do it.
Whatever your
Obliged, deeply obliged.
Item number 4.
May I please, Your Lordship? Item 4 is well covered by my lord's judgment, yesterday's judgment. Item 4 is well covered by my lord's yesterday's judgment that rehabilitation matter. Only difficulty here, my lord, yesterday personal appearance has been, direction has been given for personal appearance of the secretary and director for today.
Okay.
So, Your Lordship,
It will just follow that order.
yes, my lord, that
Taking over. You are there in this matter?
see.
This 4 also filed sent in the order.
Madam.
Item 4.
Fourth, that we will pass the order with the other matters which will be directed, not passing right now. Let those files come. They mentioned in the early part,
My lord,
right?
our difficulty, only difficulty is that personal, because it is covered by my lord's judgment. Content.
So only thing that we'll first condone the delay also.
Yes, my lord, because your lordship is disposing all these matters, so I did not place that condonation of delay and dispensing with.
Item number 5.
My lord. Matter relates to a family court matter where the family court has said that conciliation proceeding is not necessary, can be decided to be taken later stage. And also,
this is a completely a wrong approach.
Unfortunately, my lord.
Now, why are you?
I have never said, my lord. Yesterday, my lord. File as in court number
time frame.
Never, never, my lord. My senior has given the wrong statement before this court, my lord. Earlier, junior associate made statement. My lord, I have never referred to receive any copy, my lord.
Always copy. I am talking about the law. In the Family Court Act.
Family Court Act.
His only challenge relating to the order of the family judge, he says the conciliation will take later on, let me proceed first. It is completely against the very arrangement of the Family Court Act. It says the first and foremost duty of the family court.
Well, this matter is after notice, today this matter is taken up. Before that, I have never appeared before Lordship.
No, that's reached before this first day.
No, this is I appeared today, my lord. After notice matter
today.
My lord, he has appeared earlier.
Some other day.
Decided. And the other thing is suppression of fact, even though and that does not affect the merits of the case. The merits of the case, where the conciliation has to be taken place.
So he's not.
My lord, yesterday my file is in court number 2, my lord. My senior that telephoned me. I argued the matter, my lord. Thereafter, I come to the court, in court number 10. That
some other
Prepared, that was I have to ask my I have senior manager. I have associated senior manager, but in submitting that I am not cooperating. It is unfortunate manager. Yesterday, not there. Never. Personally.
He says he was on his legs.
Legs in the right at 2:30 I informed him. At 2:30 I informed him personally that we had to be taken over at 3 p.m. He did not come. And he never so such a solution out of station. My I payment my said I have also is my associate family.
You are his associate because of your family problem.
No, no, my medical problem.
Yes.
I told my senior associate that there was a medical problem. I have not gone through the trip. Only one day.
We have heard you already.
Let's see, some other urgency. Well, urgency is with regard to my lord, conciliation proceeding has not been able to take place.
All right.
One. And secondly, with regard to imposition of cost of 25,000, where
Suppression of fact. on the
suppression of
ground.
fact, because the suppression of fact it does not relate to the merits of the case. The Honorable Supreme Court said that endeavor to be done within a period of 6 months. Merits of the case relates to 6 months, merits of the case relating whether conciliation has to be taken place. I have given my pleading, I have mentioned the Supreme Court order, I have mentioned the case number, everything. The only thing, the details with regard to the Supreme Court order has not been mentioned. In this year, the Supreme Court said, all in absence, I am regarding maintenance of the appeal, against the Supreme Court order, my lord. And you know, that I will also say that I also has admitted the order of 26. See, will also just see. At the beginning, what is IN number 5252? At the beginning, an application for preliminary hearing on the question of maintainability of guilt appeal against the order of signature, part 1, session jurisdiction. Session 226, then you will see para 2. As per his own admission, pleadings, that the present respondent filed this application for reviewing the petition on the question of maintainability of the guilt appeal, where the honorable signature part an order in writ of session dismissing the writ application by the order as in past and I have said it is an inferior court. Within the criteria, let's see, some other date. I am not thoroughly prepared. I am not the.
All right, 9th of October.
Yes, ma'am.
But I will observe that he should not ask for any adjournment.
No, no, my lord. Never. After I my entered appearance, this is not first time this matter taken up, my lord. Huh?
There is no stay order.
Stay order was there.
Then you argue on maintainability.
7/7/2023, my lord. Interim means my lord.
That is why it will continue up to the next stage.
Next day, man. I am the last occasion which was now Indian.
But you should allow.
I am not objection. Initially, Lordship directed to serve a copy on it. He said the client has taken over to brief. So that is the reason the notice had to go, the matter was delayed. And after notice he appeared, he filed an application for maintainability. And the matter on 2 occasions could not be taken up due to paucity of time. Then the matter has been repeatedly mentioning as your Lordship directed that remind us to be taken up. So yesterday it was accordingly mentioned, and the Lordship has heard that he is saying that he was arguing, but his junior has a family problem, he is not there. But his junior has said that he is out of station, man. No.
Why are you coming back to that, Mr. Time. You have an interim.
All that is only succeeded in avoiding the court, my lord. No, my lord. I have never avoided court, my lord. It's unfortunate, my lord. It's obvious, my lord.
You have filed a Vokalatnama? My lord, you have filed the Bogaloth number.
Yes, my lord, I have filed your club.
Yes, yes, filed on 27 July.
Entered appearance 27th July, my lord.
Speaking I. The request of Mr. Pavitra Kumar Naik, counsel appearing for the
Respondent.
respondent. Let the matter be listed on 9th of October 2023 for disposal on merit. Yes, ma'am. No further accommodation will be made on that day. Stop. The interim order
It was 7/7/2023, my lord.
passed on 7/7/2023 in IA number
2594.
2594 of 2023 was not inadvertently continued on the previous occasion. Stop. The said interim order is restored. Stop. The interim order shall continue till the next date. Okay. All right, till the disposal.
Okay, appeal.
Stop. Whatever action taken in between this gap will not prejudicially affect the appellant.
Only one mistake because typographical error on my part. The case is shifting over 91 of 2022 because of a mistake given by me in the petition. So it will be dated 91 of 2021. It's actually 91 of 2022.
91 of already. In the order dated 7/7.
7/7.
7/7. The
Yes, number.
civil petition number. It is civil petition number.
CP number. Civil petition was 91 of 2022.
Number has been wrongly typed. The correct civil proceeding number shall be CP 91 of 2022. Stop.
Item 6.
Item 6, yesterday I had mentioned, Your Lordship. Lordship, may kindly take up the last matter, Your Lordship. The fresh matter. That is. First matter, let me file. I'm only considering the last matter because I had mentioned yesterday because the eviction notice has been issued. Your Lordship, may kindly see the WBC number 30545. The last item. The last sub item.
Yes.
Yes, Your Lordship. Your Lordship, may kindly see page 37. This is the state government along with OP number 6 had decided to implement telemedicine program throughout the state, and the petitioner being one of the entrepreneur was, Your Lordship, may kindly see page 37. Is one of the entrepreneur pursuant to the said PPP mode. The project, the telemedicine project. The 37 is, I'm concerned, that is the kit disbursement form in respect to the petitioner. The important is page 40, Your Lordship. Page 40.
Yes.
Here, Your Lordship, the state government decided that no new telemedicine center should be opened until further orders. This was stayed by this honorable court. The state preferred SLP over the honorable apex court. That is page 42. Page 42. The operative portion of the order of the Honorable Supreme Court is page 45. Page 45.
Yes.
The second para, in view of the above position, we issue the following direction. I am only concerned with direction number Roman 3. Insofar as the first respondent, namely the original petitioner before the High Court, is concerned, we record the assurance of the state which was made on affidavit before the High Court and which has been reiterated in the course of submission
in the present proceeding that the state shall permit during the pendency of the writ proceedings the first respondent to operate the notes are at present in operation, and in addition thereto 27 notes pending further orders before the High Court. The state households shall verify the exact number of notes in operation. Your Lordship may kindly see page 49. In pursuant to the direction of the Honorable Supreme Court, page 49 was issued.
Yes.
My name finds place at page number 50. The list of 27 notes which has been referred by the Honorable Supreme Court. At page 50, serial number 6. Sanjeev Kumar Nair, Borgad. Since the order of the Honorable Apex Court was not carried out, your Lordship may kindly see page 51. 51, the name of the petitioner, page 56. He also preferred a writ application bearing WBC number 32,826 of 22. Page 56, your Lordship. Page 56, the last writ petition, Sanjeev Nair and others. Page 56.
Yes.
This Honorable Court disposed of the writ application in terms of the direction of the Honorable Supreme Court, that is page 60. Page 60. Para number 4.
Yes.
In view of the above, the state government is expected to permit the trust as well as the entrepreneurs to operate the notes which are presently in operation, and in addition there to 27 notes pending further orders before the High Court. It is obvious that the above direction have to be implemented forthwith by the state government, since they were issued by the Supreme Court of India in the appeals filed by the state itself. Now, at this juncture, they have issued page 62.
Page 62.
Which is impugned, Your Lordship. That is why I made a mention. Issued on 2/9/23.
Yes.
This is by the Jilla Swasthya Samiti Borgad to the superintendent of the different CHC and SDH, wherein although the GO has already made provisions to provide medicine as well as diagnosis service under Nirmay and Nidan schemes to the patients free of cost, functionalization of such private medicine stores and patholabs resulting in a burden on out-of-the-pocket expenditure on patients. And page 63 has been issued to me. But the Honorable Supreme Court, basing on the affidavit, clearly held that we should be allowed to operate till the disposal of the writ application, which has been reiterated in the previous order of this Honorable Court, which I just read. At this juncture, they have issued the order of eviction.
Mr. Muduli, that don't evict, we are staying this order. Let us decide. We are giving you the 15 days time. Prepare the case, we'll hear the matter on merit.
That matter is ready for hearing.
Today itself. That is why I'm telling you, as you are not prepared to argue the matter, at least some protection should be granted.
Page 63 is the order which affects the petition.
Yes, that is he has challenged in the petition.
Status quo, this is state, my lord, because they have already evicted me. But the Honorable Supreme Court as well as this Honorable Court clearly directed 35 notes and 27 notes, 52, 62 notes. Yes, I'm coming.
That is why he's only one.
63, the status quo to be maintained.
No, this case he has been evicted, but the Supreme Court says he should not be disturbed.
Then you take this annexure.
Annexure 3 and also direct you to allow him to just run the note. That will give direction. Positive direction should be there, sort of in the mandatory injunction. Because Supreme Court order is there. That is the thing in his favor, very strongly is in his favor.
Here the prayer is eviction is question.
Yes.
Only trigger eviction.
Not for operating.
This it is a fresh one.
So you want to give the shell without substance. You want to give the shell without substance.
In fact, I have received the instruction in a financial matter that the verification was made in the month of May 2023. And it was found that the shop in question was not functioning.
Not sponsoring,
not functioning.
functioning.
Yes.
If it was not functioning, then the eviction notice should not have been issued, Your Lordship.
No, eviction is a separate issue.
No, it is functioning as on date, but that is why I filed the writ application. 35 notes and in addition 27 notes. Within that 27, I have already shown Your Lordship my serial is serial number 6. And the first matter relates to reimbursement, which the government is not paying. In that matter, Your Lordship has already issued notice. And the second and third matter, that is final disposal matter as per direction of the Honorable Supreme Court.
Just take the order in IA number 14734 of 2023. At the request of Mr. P.K. Madhuri, Learned Counsel, we have granted adjournment today in the writ petition. It is a writ petition or writ appeal?
Writ petition.
Writ petition.
You Lordship, grant me 5 minutes time, I will have obtained the instruction that PHC verbally, unit that is not functioning, that report is dated 2nd of May.
All right, because of the Supreme Court protection that the Supreme Court has given.
No, he will not be evicted.
That is why, if not evicted, let me also run the note. What is the difference?
If he is not functioning.
There is no justice.
Supreme Court's order might not have kindly.
Page 45.
Your name is Mr. Shukta Prakash?
Why not?
You are Mr. Shukta Prakash.
No, sir. Shubhanath Rautre.
Page 54.
54.
Mr. S. Rautre.
Page 54, my Lordship. Direction Roman 3.
Page 45. My lord.
Sorry, madam.
No, just after that, 56 perhaps.
Page 45. Page 45, Roman 3. Last line, my lord, kindly. Roman 3, last line. The observation of the state shall, however, verify the exact number of notes in operation.
That has been verified at page 50. 49 and 50.
And this page 49, my lord, kindly see what is the context. Well, there sanction was granted for opening and it was never opened. You also can see the context. Inviting reference to the subject cited above, I am directed to reiterate that instructions have been issued earlier by the department letter number 160.
You file this all the records.
Yes, I will file those reports.
You have filed it already?
No, I'm yesterday.
I will fixing it on 19th of October.
No, yesterday minor urgently to 12th October.
No, then I made a
keep it to 12th October.
12th October? No, I'm giving the longer time only because whether you can file it or not.
No, I will file the account.
All right, please the matter on 12th of October. This I number, no? In the meanwhile, the opposite party state may file the affidavit / objection in respect of the claim made in this interlocutory application and also on the subsequent events that has taken place.
My lord, kindly grant me 5 minutes time. I can get the printout of my instructions so that it can be placed before my lord.
What is the instruction read out?
This is the corrected out issued today with reference to page 63. And in pursuant to this office letter number 458, dated 2/9/2020, that is page 63. Partial modification has been made regarding eviction of Chapel's medicine store from CHC verbally.
In the above said letter, by third line of second para has been typography printed and it may be read as in the above context, the proprietor of the campus medicine store is requested shift its property elsewhere outside from the hospital premises of CHC Barpali. As the medicine note to OTTET is not functioning at present in the CHC Barpali, the letter issued earlier by the undersigned by number 458 dated 2923 has no relevance to OTT. So they have clarified that this letter has no application to the fixed.
Let a copy of the letter be given so that I can verify, Lordship.
You file the affidavit by 12th with all the materials.
I can pass on this message to the courtmaster.
No. He has a right to respond to that.
I will file this letter along with the.
Mr. S. Raut, considering to the applicant has stated that
12th.
by the order dated 2nd September 2023, Annexure 12, the petitioner has been asked the petitioner could come to know that he is going to be evicted. As the Jila Shastri Shamiti Borgar has taken a decision not to allow any private medical stores and pathologs on the same premise, in the hospital premise. So, Mr. Mudali has produced one corrigendum dated 26/9/2023, whereby it is stated that the said communication dated 2nd September 2023 has been partially modified . So now the observation is made in the said communication dated 2nd September 2023 should read as follows, quote, in the above context, comma, the proprietor of campus medicine store is requested to shift his property elsewhere outside from the hospital premises of CHC Borapali. Stop. Mr. Mudali has drawn our attention to the lines coming at the end of the said corrigendum dated 26 September 2023, where it has been noted that the telemedicine note through OTTET is not functioning at present in the CHC Borapalli. The letter issued earlier by the Superintendent CHC Borapalli Burger has no relevance to OTTET. Stop. Mr. Muduli and council has submitted that.
This is the report of second May.
Report may be. We are recording from the original number.
This is the physical verification of the month of May.
Second option is dated 26 September 2023. Just below where the communication number itself has been given. Mr. Muduli has also drawn our attention to the report of the Chief District Medical Officer and Public Health Officer Borgar, report dated 2/2023. According to the said report, the petitioner's medical store slash OTTET in the premises of CSC Borapalli is not, quote unquote, is not functioning. Mr. Rautral and Council has vehemently registered that claim and stated that because of the uncertainty created by the opposite parties, the said OTET was not temporarily working, but the applicant petitioner has all intention to run that store. In view of the above, we direct the opposite parties to allow the petitioner to run that store, subject to the final outcome of the petition.
That is not the prayer in the main district.
That is not prayer. We are passing. We are passing the order. Sir, it is 226. It is not under Order 39, Rule 1 and 2.
Just find a connected matter of 17691 of 2015. Ballots, I pray for lordship on behalf of my learned senior Mr. Milan Kangu to take the matter after lunch.
Okay. Just wait. Stop. We would request the opposite parties to file the affidavit by 9th by 6th of October 2023. Mr. Muduli? Stop. If the petitioners needs to file any response to the said affidavit, such affidavit shall be filed by 9th of October 2023. Matter is already dictated 12. Is already okay. Urgent certified copy of this order is supplied as per rule. Next.
Reading case.
Others also list and 12. Other just and list and 12.
Item number 7.
Mr. Shah, we are really apprehensive. If perhaps we are going to waste your time, we will not be able to write the judgment.
Sir, matter moves to a very short compass. You also have a hard at length, and my lords have been only one point is involved, and I think my friend will complete.
No, I can complete. He already said the minimum 30 minutes.
Yeah, let's see, because the relevant judgment passed by Honorable Bombay High Court, which has been confirmed by Supreme Court, is an identical issue, Your Lordship, in favor of the department.
Okay, let my.
So, Your Lordship, so many
let him place.
3 to 4 judgments I have to place 30 to 40 minutes, Your Lordship. minimum, because I have to conclude the argument. My conclusive 2 points.
Judgment within 5 minutes.
2 points.
I don't think it will be more than 10 minutes. Please try.
I'm not.
We are all, so much of counsels are there on the other side. We are all waiting for you to reply. So please try to finish, please. It's my request. You please start. I think, let my friend start.
What do you
Tens of
say?
counsel.
Please.
No, we are very reluctant, Mr. Sahu. Concentration is a very important issue.
Correct. Whole difficulties are so long pending matter, and we are all hopeful that at least be it a short judgment, but matter can put at rest.
No, that is there. That is also what I'm thinking and I'm hearing the matter. But now he says 30 minutes and I know the law is 30 minutes.
He'll be scrupulous in following time. I have crossed my friend.
But he doesn't himself trust himself.
Only when you have paras he has to give. I think
You have to read it.
by lunch 1:15 my friend will complete. I don't think.
Oh, no.
And we didn't enjoy. That is only
That you have to make.
because we have already given a lot of information. My friend has also
My lord has to pass the order.
I know.
Let it go to some other bench, I think. I'm feeling very sorry. That was I was thinking what to do. Short date I'm giving.
At the 11th hour, we don't want to disturb your lordship.
That is the thing.
I just lordship may keep it at that, not let it be with liberty for given to us to mention before.
That will give. I may also fix a date also, specific date.
Bernard, you will also. You will
Particular date. Just let it be open with liberty to us to mention.
All right, Mr. Mishra.
And the interim orders to continue to have.
All right.
Your Lordship, please, because in all these matters at the beginning also I have requested your Lordship to segregate. So far as the REIT and your Lordship to, because there are many Lordship, all those have to be paid your Lordship by your Lordship. I know your Lordship because because it is not a single issue, even though it is a single issue,
but there is a factual way.
So all because filed written submission, your Lordship has to go.
But point is a central point is one.
Your Lordship, yes.
Let these matters is a partner must be released from part. Let this matter be released from part to be listed before the assigned bench in future. We grant liberty to the petitioner to mention for listing for hearing. Give the name of the council. See the old order. I'm sorry, I'm doing.
Grateful your lordship has given us a patient hearing.
Thank you.
Your Lordship,
ultimately, if anything doesn't go to this pinnacle, this useless exercise. Correct. All right.
Your Lordship, I am appearing.
The matters came, all those matters are listed.
Interval to continue. Interval is already.
If the model is passed earlier, shall continue.
Your Lordship, I am appearing on behalf of the in the
old orders you have recorded.
I am also appearing on behalf of Finance Secretary. I am also appearing on behalf of the Finance Secretary Government, Your Lordship.
Finance Secretary. Mr. Mishra is also appearing for the press.
I'm Commissioner.
The same person, Commissioner of Tax.
Your Lordship, originally I am appearing on behalf of the department, but in this cases, government has instructed me to appear on behalf of the Finance Secretary Finance, Your Lordship, Principal Secretary Finance. Shall I pass on one later? Shall I pass on the letter, Your Lordship, so far as my appearance, so far as the Finance Secretary is concerned in these cases?
No, we will not accept it. We give a reference to this letter and file your memo.
Your Lordship.
You have nothing to do with your Finance Secretary.
Your Lordship.
Item 4. Item 4. Next date.
In all the matters, the finance secretary is not part.
Not party, only repeat, some of the repeat, only repetitions. So all STRBs I am appearing on behalf of the department. In the repetition along with
Yes, may I pray your worship? Yes, STRB 26, 27, 28 minutes. In those cases, your lordship have issued notice. But formal question is to be framed. Because all STRB matters, as my lord knows. So questions may be framed, the matter will have to open for decision that one. Only question.
same thing.
What is
At the time of disposal also question can be framed.
STRB 26, 27 and 28.
So this is identical matter?
Identical matter. You lordship issued notice. Questions are there in the particular.
In the similar STRB matter, question has been formed or not?
Yes, in matters I am appealing questions are framed.
Which one? This is on board today?
59.
STRB 59 of 17.
That is on board today?
Yes, your lordship.
Yes, just find out the order. You already dictated 26, 27, 28 STRB, huh?
26, 27, 28.
All right.
Much obliged.
Why is that file?
59 ACL.
Just show it.
Lafarge cement.
May.
Lafarge.
Madras cement. Madras cement. Madras cement question is framed, but Lafarge question is to be framed in identical terms. Sorry. Questions are already there in the petition itself.
No, because if it is identical matter, I would just quote that question from there. This is the question, whether the facts and circumstances of the case, Learned Odisha Self-Tax Tribunal is justified in applying section 20. That is the question.
Section 20, no.
That is the question framed in this case which you are referring.
So let it be worse there, because confused.
Section 22J.
Yes, J, sorry.
Because I am reading for 20J.
No, 2J minus, yes.
This part, just name of the parties, admit on the following substantial question of law for determining the revision. Whether, but the subpara, whether in the facts and circumstances of the case, the Orissa Self-Tax Tribunal is justified in applying section 2 within first bracket small j of the Orissa Entry Tax Act and estimating the purchase value on the basis of the sale price of cement. Unquote. There is also Lafarge's cement.
Correct.
List this matter along with the analogous matters pending listed today.
Item 4. Item 4, my lord, that relates to appointment rehabilitation assistance scheme.
Who is appearing in item 4?
In item 4, state is the party.
Notice has not been
noticed. First time it has come, my lord, the print. I am submitting that case is covered by my lord's judgment.
All right.
And what is the difficulty, my part, my lord, that direction has been given to appear in person by the secretary and director. So the matter has been passed over to after launch. So that's the difficulty.
No, they are present today.
The director is present, secretary has not come. The matter has been urgent, has been passed over after launch before honorable single judge. So if your lordship will dispose of this matter that with that observation.
Can you remember yesterday's first case number?
That 810-2020.
Please give the name of the parties.
Item 7, yesterday item 7. 2 p.m. Yes, my lord.
Heard Mr. M.K. Kuntial and counsel appearing for the appellant. It is apparent that appeal is barred by limitation as there was a delay in filing the appeal, delay of 192 days in filing the appeal. But Mr. M.K. Kuntial and counsel has submitted that in view of the order first in a batch of writ appeals filed with the state of Orissa, this appeal will Orissa in State of Orissa versus Bindu Sagar Samudraya within bracket order dated 25th September 2023 in WA 810/2021. The said in the said appeal, state appeal was dismissed with certain observation.
And disposed of my.
Was disposed of with certain observation. Mr. Kuntial and government advocate has fairly submitted that in the similar manner, this appeal can also be disposed of in the similar terms is recorded in the order dated 25th September 2023 in the batch of writ petition, including WA 810 of 2021 as referred above. So accordingly, this appeal stands disposed of. The respondent case shall be considered in the manner as recorded in
time limit that
Bindu Sagar Samudraya within a period of 4 months from today.
I may be pardoned to mention.
Let me. That contempt petition that is pending before the Honorable Single Judge.
You just go there. The personal appearance is directed by this court stands dispensed with.
I may be pardoned to make a mention, my lord. My lord, in the morning, I had
My lord,
mentioned.
may I pray, my lord, that 3 copy of the order is
a copy of this order
so that I can provide.
Additional government
My lord, writ appeal number 1705, I had mentioned in the morning. Your lordship has.
They have mentioned that 3 other matters, 5 other matters, rehabilitation is true.
Those matters are identical to yesterday's state one.
And I have seen all those files.
Taken on board and
yes, I have seen all those files.
We will pass because we have disposed of that matter. It cannot be checked. I forgot that. There's the similar way we will pass is this order.
Similar, my lord.
Same way, huh?
1705, my lord.
Yes, 5 cases are all of
you prepare the same way you prepare another judgment. Combined. No, it is separately. They will be given some list 4 files. Same way, no? Same order. Only the constituent will be coming. Then separate small orders will pass. 5 records. 5 records, okay. All are disposed of?
My lord.
In terms of this judgment?
My lord.
appearance named.
Appearance named.
Slip.
My lord, I'm giving it.
So,
highly obliged.
we are not supposed to come at 2 now. No. So, Mr. Mishra, you're coming?
My lord, if your lordship permits me, I think section 20 will clinch the issue. Because section 20
overriding effect.
Much obliged to your lordship. So therefore, because once the family court seizes with the jurisdiction to deal with particular things, there the judgment will come in section, your lordship, they have mentioned where the judgment will come. Judgment will come in section 17, which will be applicable in 19, subject to the limitation provided in 19, because 20 says notwithstanding anything contained in any other law for the time. And the Honorable Appellate Court, I may be pardoned, I could not make the adequate copy. 21 Supreme Court says, my lord, it has been dealt with in paragraph 17 and 18. That clinches the issue.
All right. But problem is the Bombay High Court full bench.
Now, everything will go because of this, and very fact that 2022 Supreme Court said there is need of enhancement of limitation. So the purpose of the court were conscious of the fact that limitation is 30 days. So there was no question of observing that legislature should amend and make it 90 days. If the court would have accepted the suggestion.
In Savitri Banda, court has not also directed that it will be 90 days.
Much obliged, madam. Yes. And this 2021 Supreme Court paragraph 17 and 18 dealing with section 20 clinches the issue. Your lordship may kindly see. I may be pardoned, I couldn't make adequate copies. We have given it. So your lordship can, we can produce it.
Yes.
Mine also has that same Arundhati Singh. After Arundhati Singh, the issue no longer remains.
Correct. And all those, your lordship has been pleased to formulate the reference. I think is answered because of this judgment. And that was vis-a-vis in the context of Special Marriage Act, but the issue is with regard to section 20 that has been dealt with. Okay. Paragraph 17 and 18.
Yes. In the Family Court Act.
So we thought there will be much labor on this point, but in view of this, the judgment of the Honorable Appellate Court, I think
we should not complicate the matter more.
This has to 20. The 20, I was just thinking of 20 yesterday evening. So that is 45.
Order of the
Section 20, I have dealt with in one of my decisions sitting with Honorable Justice B.K. Patnaik. B.K. Naik. That whether dismissal of Order 1913 application by a family court is applicable or not. That section 20 I had dealt with.
2021 SCC Online, Supreme Court, 3285, paragraph 18.
And that is what I have told before the Honorable Court.
It's at page 7 of that short note, it is there, that para.
I can see that. Nani hasn't read.
Recently, also on 12/9/2023, Delhi High Court delivered the judgment recently on 12/9.
Same.
Same. That copy is with me. I think it's a little a variance note on that. I'm aware that the judgment which Mr. Mishra and both the Mr. Mishras handed over. Of course, it was only analyzing that whether the condonation Section 5 application should be filed or not. And in that line, they did analyze. They said that, yes, the limitation is going to be 30 and therefore you'll have to do it. And they just confined it to 20. But the fact remains that even after that judgment, there have been judgments in other courts also, and including the Gujarat High Court, which prefer to follow the Bombay High Court judgment. The only issue is that this judgment is not really taking care of the earlier judgment, where the court actually directed that, we should have an enhanced period limitation. And that enhanced period limitation of course, which was...
No, that is, you are referring to Savitri Pandey.
Yes,
Because in
did
the Supreme Court, no, that is an issue in that. Savitri Pandey is a totally, first of all, there is two aspects in this matter. Savitri Pandey, even the Supreme Court did not declare the law that it will be 90 days.
Yes.
Here is a jurisprudential issue, whether the court has the power
to actually,
to make a provision, express provision of law into an OTS.
The only issue I think with the Gujarat High Court came up, and I do not know how much it will apply in our state.
Actually, what the Gujarat High Court judgment I have read, they says it is a non-obstantive clause. So therefore, the ordinary principle of statutory interpretation will not apply. But in my considered view, this subsection 4 of section 19 is not a non-obstantive clause. It is not dependent on the other clause. It is itself an independent clause.
I'm not banking on that aspect. What it did say is one thing which I think was a little aspect which we need to ponder about is that only there where you have a family court constituted, there this limitation comes into application. But we don't have, and that's exactly what is that Delhi High Court judgment. They said where there you have it, it will be 30 days. And when you don't have it, it's 90 days. That's what the Gujarat High Court also found it disturbing, that you are actually providing two limitations for literally for the same rights involved between parties. That's the only...
there is a differentiation. We have to take care of that. Because in the Hindu Marriage Act 1955, section 28, procedure that will be followed of the Code of Civil Procedure. There are various steps. Right?
Gotcha.
Even an appeal file under subsection 3 of 28, that will be appealed like a civil appeal. But the very idea of bringing about this Family Court Act to frustrate the adjudication, that is on everywhere there is a point that you have to beat the time scale and you have to just come back to this appeal also the shorter period. One issue in both the judgment, in Bombay High Court judgment and Gujarat High Court judgment has taken, surprisingly, is that the more time, if not provided, the people will face the harassment.
Which I think to some extent has a basis, because when we are looking at divorce and marriage as an institution, various categories.
All right, I am telling you.
A Dalit woman from some village, I would see it differently. Of course, we have a condonation application, I'm not saying that.
That is the provision is there.
Condonation is there always.
So therefore, that's also taken. But yes, I think that was probably the whole idea. But I think
whatever say, we should give the letter to the parliament.
The parliament did not come up with the corresponding, I think, amendment in the Family Courts Act, which probably it should have.
Is that the argument to what Ms. Rath is hinting at? She is hinting at it should be 90 days instead of 30 days.
No, I'm not.
And she's not hinting at that.
Basically, that is what she has my submission to you, actually, notwithstanding Arundhati Singh, notwithstanding the recent judgment of the division bench of the High Court, but what is required in the present case is that one has to look, one is a special statute, that is the Marriage Act, and the Family Court Act is a procedural matter. Statute. So procedural, it is right law that
it is a mixed bag. It is both procedural and substantive statute.
But yeah, any procedure under the Family Courts Act has to be under either the Special Marriage Act or Hindu Marriage Act or Indian Divorce Act or whatever. It is guided by some other statute. So it is the special statute which would prevail over the procedural law. That is one. Second is, there is an apparent contradiction between the provisions of the Hindu Marriage Act and the Special Marriage Act. Now, what would prevail over one over the other? That, my lord, Supreme Court has answered, my lord, in one judgment, if I may. I have prepared a small note.
60 days.
And in this judgment, I've also extracted this portion, what I'm trying to put forth before your lordship. Paragraph.
Without joining issue with my learned senior man.
Yes, sir.
The Supreme Court had made clear in that judgment, saying that it's 30 days. And if my lord would see those paragraphs, because after the Supreme Court has said something, probably then we all have to travel to Delhi. Because I think here, once the Supreme Court says something, then I think
your lordship may take this judgment.
Very showing sections have come for interpretation. They have said that it's 30.
Well, this is a judgment which had again traveled from this honorable court to the Supreme Court. Supreme Court has answered it. Your lordship takes page 24 of the judgment, paragraph 23. May I read out from paragraph 23?
Yes, sir.
In the instant case, there is a clear conflict between the proviso of section 200 of the OEA Act 1951 and section 5 and 33 of the Temple Act 55. It is also clear that both the above statutory provisions of the Act cannot survive together. While the rule of harmonious construction must be given effect to as far as possible, when the provisions of two statutes are irreconcilable, it needs to be decided as to which provision must be given effect to. In the instant case, section 200 proviso in its entirety is not violative of the provisions of the Temple Act. At the cost of repetition, we reproduce the relevant portion of 200 of the OEA Act as under. They are quoted. It is only the first part of the proviso which is in contravention of the Temple Act 1955. If that part of the proviso continues to be given effect to, Section 5 and 30 of the Temple Act 55, by which the estates of Lord Jagannath Temple at Puri are vested in the Temple Committee, will lose their meaning. By striking down Section 200 proviso to that extent, both the provisions will be able to operate. Thereafter, they have gone on quoting various judgments. Thereafter, at the next page, last part of para 23, it becomes clear from a perusal of the above mentioned two judgments of the court that while provisions of different statutes must be harmoniously construed as far as possible, in cases where it is not possible, this court needs to examine as to which provision must be given effect to. In the case at hand, the first part of the proviso of section 200 of the OEA Act cannot be allowed to sustain. Clearly, the intention of the legislature could not have been to render virtually the entire Temple Act enacted on the specific subject meaningless by way of enacting a proviso to section 200 of the OEA Act 1951 as an amendment in 1974, which is in the general legislation in the instant case. Section 200 of the OEA Act 51, thus to that extent, requires to be struck down so that both the OEA Act 1951 as well as the Temple Act 55 can be given due effect in their respective field of operation. In exercise of powers conferred under section 142 of the Constitution, the court can pass any order as may be necessary for doing complete justice in a case before it. In the instant case, great injustice will be caused to the appellant temple if the rights conferred upon it by the Temple Act are allowed to be taken away by operation of the proviso to section 200 of the OEA Act. Therefore, we have to strike down the proviso of section 200 of the OEA Act and quash the notification.
So, Mr. Mukherjee, this is special feature of the judgment is that there is a common area of operation.
Yes.
Right?
And here also there is a common area of operation.
No, sir. That is where is the divide, exactly. The fracture. Because if you go through the channel of the Family Courts Act, it is a complete procedural court.
Yes, it is a procedural court.
Even you just see this section 19 subsection 1. It is a much broader section. In its embrace, every order comes. If it is not an interlocutory order. But that is not the case. Then you go to the subsection 2 of section 28. That there is certain other conditions is there. No appeal will lie. There is a restriction.
But as I pointed out, here your lordship has to weigh the situation. A person in Malkangiri, or for that matter in a far-flung place,
No, sir, for that, condemnation of delay can be made.
Can be, but it's the condemnation of delay is not a right.
But
it's an application again, and while statutory right, an application filed under section 5 for seeking condemnation of delay is not a statutory right vested in me.
Yes.
So I am at the, while I can exercise the right of appeal, this is not something that I can really ask for from the court.
No, there is another secondary issue is that whether the court has the jurisdiction to say this will not apply and this will apply.
Court can strike down that portion of that.
Challenge that law. That is different matter. On the principle of striking down, this will not come. Independently, if you analyze and examine those provisions, we cannot strike down.
Right now,
the provision will survive. Unreasonableness, the provision will survive. 30 days, there is a lot of statutes are there. The 30 days is the limitation period.
I can understand that in commercial law, I can understand that in industrial law, where the people are
not industrial law. There is a Prevention of Domestic Violence Act. What is the appellate period?
But there the appeal doesn't lie to the High Court. Here the appeal from the family court's order lies to the High Court.
Yes.
And there is this logistical difficulty of a person in the remote part of the state to reach.
No, that barrier is no more there.
If so the
Odisha is concerned, that barrier is not there.
So I am concerned that barrier is there.
I would just to add to this that the barriers that we see, we are only seeing from the point of view of the system, and it's a fact that a lot of us will see it from the lenses of being
That is very correctly referred to the Savitri Pandit's case.
Yes.
Just see, all the reasons were given by the Supreme Court, but did not lay the hand on the
I agree. We do, our hands are tied, but this is fact is that the litigant who comes to the court, for that litigant, the barrier, especially in domestic matters,
of interpretation, we cannot make a solution of law.
Our hands are tied. Our hands are
And we
tied.
cannot play the role which Parliament should have played.
Should play.
And that too,
the parliamentary people are honorable about the people from the far off place to the distance of the High Court. Must have analyzed that also.
No, they did. They did say. They did say that a person who's coming to the court will have many cultural, social.
Why 90 days? We can make it more, 6 months. Very comfortable.
One has to raise.
Fundamentally, the limitation is an issue of the public policy to shorten the litigation.
To shorten the litigation,
Exactly.
but there is also
so there is an element of hardship always is there.
there is an issue also that's the period that any party has also to bypass before he takes his second chance for this institution. So that's another aspect of the matter also which is there.
I think if you go for a survey in our High Court also, what is happening in the limitation application? I can, without going through the record, I can say that 98% limitation applications are allowed.
They would be. In fact, they would be. In this cases.
Yes.
I think the strictness is only.
Panagra is also a party to that. Life is delayed. 5 years delay. That was rejected. Well.
Every jail has all facilities to approach. We have this welfare officer there. If it doesn't want to contest, it doesn't want to appeal. All facilities. We don't have
So what? Now, after this reference was made by the order, this Arunodoy's case has come. Now the question of Article 141. Whether we can debate it or not.
Just one more thing from that judgment.
All have seen that judgment.
That paragraph, they have analyzed everything, paragraphs 14 to 18. And they, it might not be just allowed to show that.
Yes, you can read it.
Paragraph 14 from page 7 of that note, which I have prepared. SCC online version judgment.
Yes.
So in paragraph 14, they take note of 29(2) of the Limitation Act. Paragraph 14.
Yes.
Section 29(2) of the Limitation Act says that where any special or local law prescribes for any suit, appeal, or application, the period of limitation different from the period prescribed by the schedule to the Limitation Act, the provision of Section 3 of the Limitation Act would apply as if such period were the period prescribed by the schedule and for the purpose of determining any period of limitation prescribed for any suit, appeal, or application by special or local law, the provision contained in section 4 to 24 inclusive shall apply. Para 15, under Article 116 of the Schedule to the Limitation Act, the period of limitation prescribed for an appeal to the High Court from any decree is 90 days. The period of limitation for appeal to the High Court from the decree or order of the same court is 30 days. Section 39(4) of the Special Marriage Act also provides that every appeal under aforesaid section is to be referred within 90 days from the date of decree or order. However, as observed by section 19(3), this is important, my lord.
Yes.
19(3) of the Family Courts Act requires every appeal from a judgment or order of the Family Court to be filed within 30 days. The provisions of the Family Court Act have the effect notwithstanding anything inconsistent contained in any law for the time being in force. Para 17, section 19(3) of the Family Courts Act provides a shorter period of limitation than section 39(4) of the Special Marriage Act or Article 116 of the Schedule of the Limitation Act. There is an inconsistency between the period of limitation for filing an appeal prescribed by the Family Courts Act and the Special Marriage Act, as also the Limitation Act. By reason of the non-obstante provision of section 20 of the Family Courts Act, giving overriding effect to the Family Courts Act, the period of limitation for filing an appeal from a judgment or order of a family court constituted under the Family Courts Act would be 30 days and not 90 days. Milord, these 4 paragraphs, with great respect, Milord, clinches the issue actually.
With your lordship,
my lord,
if it's within 90 days, that will amount to encroaching upon the legislative domain, which is not permissible.
Separation
So that,
of powers.
yes. And your lordship's decision, my lord, which your lordship, my lord Justice K.R. Mahapatra was pointing out regarding this 20 overriding effect, that has been dealt with in Jagyansis Jana case. My lord, I'll give that reference. I have got it. They are in section 20 in the different context was dealt with.
Yes.
But
This paragraph 22 was
It will not be referred to.
any other basis, but a contrary view has to be taken. It can only be taken by the Honorable Supreme.
Exactly. While we are legislation.
No, because now we can debate because it is our own High Court judgment.
Absolutely. And even constitution benches judgments are again being reconsidered. And mercantile has now been referred to 7 judges.
A lot of matters have been there.
So it can always be reconsidered.
We can see the legislative changes are also there.
Absolutely.
Not logic, but experiential experience. So I think
While we have the question of limitation, one very important fact, since I do spend some time in the trial courts also, which I need to bring to your lordship's notice, a lot of circumstances and situations are coming where the case is posted for orders to a particular day. There is no order on that day. The order sees the light of the day at about 15, 20, 30 daage thereafter.
That cannot be the ground. Mr. Mukherjee, I'm telling you.
No. I'm telling you what the difficulty that the litigants are facing. But it comes with the order of the date to which it was posted. That is where the difficulty arises.
No, that cannot be any difficulty. There may not be any difficulty because
If you make a copy application, it's not entertaining the copy application because the file is not illegal. They are not entertaining the application. That's the system.
That is addressing it. We are addressing it. We have already issued a
because we are not entertaining an application for an urgent copy or certified copy even on that day. Because I had also exactly what fell from your lordship. I had done that. I asked my office to make an application on the very same day, but the application was not.
In one of the cases, the order sheet shows issues settled. When I called for the record, I saw that no issues is there. There is no
after the judgment was released.
At the time of writing the judgment, only issues.
That's a normal practice.
That happens.
Okay. Okay.
And that procedure is going on from 2017, my lord. Your lordship has.
No, that is the unfortunate part that some odd person comes in the institution and finds out the greater things.
And maybe possibly with permission, the coolest Honorable Chief Justice.
Yeah, the Section 5 application, I think the heart of the judge.
Oh, I share your anxiety. That is why I'll be talking to my brothers judges whether we can make that while considering any application under subsection 3 of section 19, there should be the wider latitude in considering all the aspects. That if you can observe, I think that will be part, but without confronting the statute.
Yes.
And that is a general principle of the limitation. And we should be only reiterate the things. And it happens because the judges who sit in the matrimonial courts, they're very kind-hearted judges. No, because they say that let us explore a further possibility, whether the relation can be reconstructed or not. That is always there.
And it has happened in your lordship's court quite often, my lord. There has been reunions and everything.
There are various kind of voices today in India. Some think that
you are saying that
of living, and some people
life of law is not logic, but it's an experience.
Yes.
That we are not trained. I'm telling you, there's a defect in our Indian judicial system. Our meditator, there's meditate the matter. And the mediation is a special kind of a training is required. In US, you go through, they're the specially trained persons. They have their own offices. They call the counselors, or sometimes they call the consultationist or the psychiatric consultation, whatever name that. But lawyers are going to understand all the nitty-gritties of the relation problems, because we are not getting also the 80% of the information, which is very material, to understand the complexity of this crisis. Because nobody will give you the information. We say that it be intimate and try to explore there's a background of this case, but it's very difficult. Next to impossible, that is the failure of mediation is very high in India.
There's one thing also, Your Lordship, that I have been feeling is that we have litigants from all sorts of background. A couple which lives in the urban setup would want to get over with it very easily because they're well equipped. There are various sections in our country which depend on that institution. And in fact, even to walk out of the institution would be a call of the society, not of that individual. So there are various kind of things happening.
The pressure of the social, nobody can actually absorb that. It's very high.
Very high.
Very high. Anyway, now we'll make it short.
Now that report, my lords, conclude. In fact, after getting the notice, I have done some endeavor to address my lordship.
I do not know what happens in this court. What we followed in our courts, that whenever a matter is a disco, you all give the notice to the all senior counsel.
That's right. Correct. But then I have only just prepared with, instead of taking much time from my lords, I am giving the judgment, some additional judgments already cited and supporting that 90 days limitation theory.
Okay. Because Supreme Court has settled that issue in the school.
21.
I asked the 2002 that.
This is Savitri Pandey.
Savitri Pandey says, it is Gujarat High Court, Patna High Court,
At least,
Kerala High Court, Rajasthan High Court. They have all given the judgments without agreeing to 90 days proposition. I've given those judgments for my lord's reference.
After Arunadha Singh, there is.
Not 30 days.
Of course, when senior counsel Mr. Mukherjee and
This is the real
Mr. Rastafari.
I am the counsel for the Atlantic.
All right, that is
You are worse in a stall.
21 Supreme Court is cited by my learned friends, but that what notwithstanding will start that non-obstant clause, to what extent it will be binding, to what extent it will be mandatory is dealt with by certain other high court.
No, the Supreme Court is a section about section 20 of the Family Court said they have given a categorical finding that it has an overriding effect.
It is vis-a-vis the limitation also, section 19.
But I am giving those the for my lord's style.
And in that judgment also they have said that section 5 of the Limitation Act will apply, which fell from your lordship. That Arunadha Singh also deals with that question. And
no, there is a special section for the condonation of delay under section 19 also. But the principle for consideration can always be applied and is applied also.
That also they have reiterated in that judgment.
Proposition of loggerhead between two special acts.
There is no loggerhead.
Section 28.
There is a perceived.
Section 28 for 90 days for filing of appeal. And this 30 days for filing of appeal. Your lordship considers if a person comes, gets that decree, to approach the High Court, it is 90 days as per the Hindu marriage. Now, under the Family Courts Act, it is 30 days. So that's the reason I say that both the statutes governing over the same field, on the question of limitation, there is a conflicting proposition.
First of all, the area of operation of the law.
Yes, correct.
No, right. Only when this conflicting relation can be explored or discovered, when there is an option. But when you come under this Family Courts Act, there is no option. You have to go by this procedure.
In view of that word notwithstanding. In view of the word notwithstanding. But then if I not say 89 Supreme Court I have given. Honorable Supreme Court in this very Hindu law, that's a Hindu Marriage Act again is a special. That says Hindu Marriage Act again is a special.
And that is why we are discarding this proposition that there is an area of commonness or there is a conflicting relation. Only then Savitri Pandey's case or this case, present case of this High Court will apply that there is a conflicting relation, which I will choose.
Yes.
We will say no, there is no conflicting relation. The moment you prefers in the procedures, one judgment for a different context I refer to in 1976, there was a question was raised in a labor dispute. The common thing will go to the labor court. But when the question regarding whether the labor court has jurisdiction, right. I'm telling you, just wait.
Yes.
Supreme Court says that this is a question of option, where it will be tested, which has the jurisdiction. Again, it's limits. Give the option, but limits. The moment you go to the civil court, you have to go by the process and procedure of that court. That is the observation of the Supreme Court. And they say when you come to the industrial tribunal or the river court, you will be guided by that procedure only. Area of operation is very important. But basic question is not there, whether the court has power.
Yes, that is.
To just kill an express provision. Maybe it's absolutely a wrong law. I have one judgment I have passed, I am telling you, even it has not been amended. This NDPS Act, section 27. Amendment has been done. The 27 subsection 2 and corresponding with the definition, you cannot, in harmonious reading, you cannot give. As a result, all the prosecution should fail under section 27.
No. Then are your lordship proposing to say, subject to my understanding, my lord, Hindu Marriage Act and Family Courts Act, both of them operate in a different field And somebody can approach.
So what the procedure is concerned.
Yeah, exactly. So far as the
Procedure is concerned.
Yes.
Otherwise,
Procedure with respect to limitation. All that we are discussing.
No, appellate provision.
appellate provision also.
Yeah, we are now.
There you can a comparison between the section 19(1)
Right.
and section 28(1). You will find the difference. In subsection 2 of the section 28 says the orders which are not appealable.
Doctrine of election there. Because whether I go to civil court or I go to criminal court, I don't have a election there.
No, there is no election.
You have to go.
Yes. Yes.
There you are. 2009 allowed.
Uh-huh.
You are not giving that judgment for minority.
Yes. But the problem is, Mr. Mukherjee, again, the jurisdiction of the court. It can be a subject matter in the parliament and is a very good subject matter, whether they should be there or not. And maybe our failure sometime will be just make the legislature wake up to the
Write 2 letters. 1 letter, all the family court matters should be ended within 1 year or 2 years. And this.
That is right reasons why family court.
From all the senior advocate of Orissa High Court.
Family court 30 days, yes, district court 90 days. That's probably.
That is decision. That is Article 141 is there. Yes. Yes. You are absolutely, there is a point when there is a Mr. Mukherjee was saying this, where is the question of election? Where is my I cannot choose any jurisdiction.
Exactly. Wherever a family court is that,
I have to go there.
Yes.
Necessary.
Yes.
It's a next question, maybe legislation.
The another question may also come, very academic, not at all related to the thing, that how the family court approaches the problem. There is no formal recording of the evidence. As yet, there is no rules. No court has adopted that.
Summary proceeding. High Court generally 90 days for see other corresponding laws, CPC second appeal, or criminal division, or even any other, not against any final order. 90 days limitation for all the.
Mr. Rother, one thing I am telling you, that neither this provision has been laid down or formulated.
Allahabad High Court has suggested family.
That is Savitri Pandey also did not say that it is bad laws.
Yes.
Ask the legislature to just consider it whether it should be changed or not, and then it has been changed. Why should I do that? Because Supreme Court judgment is now this.
I understood. It's not coming.
No, we did not like to shorten the matter, but we are.
And there is nothing to debate in fact.
Exactly.
For that reason. And regarding that evidence your lordship was referring to by the family court, section 14 says how the evidence is to be taken. It says the family court may receive as evidence any report, statement, document, information or matter that may, in its opinion, assist it to deal with effectually with a dispute whether or not the same would be otherwise relevant or admissible under the Indian Evidence Act.
Whether it will be permittable when in a the matrimonial court, either additional district judge or the district judge court, this type of evidence will be accepted.
But this is what Family Court Act provides.
Exactly so. This is a special arrangement
expressing concern.
Even family court can accept a letter received from the various sources of evidence. All it. But in order of seniority, Mr. Gautam Mukherjee.
Mukherjee will be senior most. Mr. Mishra will be below him, then I'll.
No, that way he definitely senior. That seniority is taken.
Senior advocate, Mr. Gautam Mishra, Senior Counsel. Then you, in order of list, I have not seen how it is possible.
If it is order of senior, I think I come after Mr. Mukherjee.
All right.
But I only see one.
Mr. Leonard, Senior Counsel, Mr. P.K. Roth, Leonard, Senior Counsel, M.S. Kwame Roth, Leonard, Senior Counsel, then Ms. Deepali Mahapatra. D. Mahapatra is a dangerous thing. Someone, 3 lawyers said there.
Yeah.
Third counsel. who was appearing for the appellant department from which these references emerged. So,
Mr. Dwivedi, he's for the respondent.
already you have appeared for the respondent.
And Ms. Mahapatra appears for that.
Mr.
Suryakant Dwivedi.
S.K. Dwivedi. Land Council has appeared for the respondents in the appeal. So by the order, dated 15/5/2023, passed in committee number 54 of 2020, titled as Vibhuti Bhushan Raut versus Shoshmita Naik and another. A division bench of this court, noticing the decision of Srimati Swarnalata Naik, alias Nahak, alias Lady versus Manoj Kumar Naik and Ratnamala Nahak, 2017, Roman capital 2, OLR 802, where a division bench of this court had held that for filing of an appeal under section 19 of the 1984 Act pertaining to the proceeding under the 1955 Act, the period of limitation will be 90 days. Stop. The Family Courts Act 1984 has 94 has laid down the provision for limitation under section 19(3). In the following manner, 3, every appeal under this section shall be preferred within a period of 30 days from the date of judgment or order of a family court. Stop. The division bench which held that the limitation period will be 90 days at par with section 28(4) of the Hindu Marriage Act 1955, held that the apex court in Shabitri Pandey versus Premchandra Pandey, AIR 2002, SC 591, had observed that the period of 30 days is inadequate for preparing and filing an appeal. Therefore, in Sabitri Pandey Supra, the apex court directed the state to reconsider the provisions of period of limitation under section 28 within bracket 4 of the Hindu Marriage Act. Pursuant to that direction, the Section 28(4) of the Hindu Marriage Act was amended by extending the time of limitations to 90 days. In Swarnalata Naik, a division bench of this court, on consideration of the reasons provided in Savitri Pandey's Supra, held that even in case of appeal filed under Section 19(3) of the Family Courts Act 1984, the period of limitation will be 90 days. Stop. It has been observed in Swarnalata Naik as follows. Quote, it is well established in law that the procedural law is always subservient to the substantive law. While provisions of the 1955 Act are substantive in nature, the provisions under quote unquote the 1984 Act are mainly procedural. Therefore, the period of limitation is provided under the substantive law for filing the appeal would prevail over the limitation period prescribed in the procedural law. 2. While subsection 3 of section 19 of the 1984 Act deals with a general provision, semicolon, subsection 4 of section 28 of the 1955 Act provided 90 days period of limitation as incorporated by UFN amendment on 22/12/2003, substituting earlier period of 30 days of limitation, is a special provision in the background of the observations of Supreme Court in Savitri Pandey versus Prem Chandra Pandey reported in AIR 2002 SC 59. 3. The purpose of amending subsection 4 of section 28 of 1955 Act was to overcome the inconvenience and hardship faced by the litigant public, as pointed out by the Supreme Court in Savitri Pandey's case within brackets Supra, keeping in mind the purpose of amendment of subsection 4 of section 28 of the 1995 Act with effect on 2012-2003, the period of limitation is provided therein must be given prominence and predominance. 4. Where two interpretations are possible with regard to the limitation period, the one stipulating the larger period of limitation is to be preferred. 5. 90 days limitation period is provided pursuant to the amendment of subsection 4 of section 28 of 1955 Act, which was brought in by the Act 50 of 2003, substituting earlier period of 30 days being a product of later enactment has to prevail over subsection 3 of section 19 of the 1984 Act, which is an earlier enactment, unquote. Stop. The division bench which referred the matter for consideration by a larger bench formulated a few questions for consideration, suggested a few questions for consideration. For purpose of reference, those are reproduced below. Just copy those questions separately there in the judgment. We have heard the London Senior Counsel and the counsel appearing in this proceeding. There is clear two sets of views have surfaced. One view supporting the view as taken by the division bench in Swarnalata Naik, and the other set of view has negated the proposition of Swarnalata Naik. So, it has been also pointed out by the Learned Senior Council that while considering Swarnalata Naik, the provisions of Section 20 of the Family Courts Act was not taken care of. Section 20 provides as follows: Act to have overriding effect. The provisions of this Act shall have effect notwithstanding anything consistent therewith, content in any other law for the time being in force, or any instrument having effect by virtue of any law other than this Act. Stop. There cannot be any amount of dilemma in understanding the purpose and purport of the Section 20 of the Family Courts Act 1984. Stop. What the division bench in Swarnalata Naik has observed is very difficult to accept for three fundamental reasons. This one, even in Savitri Pandey's Supra, though the Supreme Court found the period of limitation under Section 28(4) is very short, inadequate, and required expansion, but they did not substitute the statute by providing a different provision. And the reason is understandable. Stop. Though in Savitri Pandey, the apex court had strongly recommended for the legislative change, but the court did not make the said change. Stop. The domain of the court doesn't extend to legislative. Therefore, the court has to exercise a refrain while dealing with any provisions of law. Moreover, it is the well-acknowledged canon of interpretation of law that by way of interpretation, any provision of a valid statute cannot be made odious. Stop. 2. In view of the non-obstante clause in Section 20 of the this Family Courts Act, no other law can have any conflicting relation with provisions of any conflicting relation with any provisions of the Family Court Act. Therefore, there cannot be any occasion, at least that cannot be contemplated, there will be any occasion to make reference or to locate for dominance between the two provisions, i.e. the Hindu Marriage Act 1955 and the Family Courts Act 1984. Stop. No valid interpretation can be structured on the age of the legislation. What is important is that the area of operation for purpose of locating the conflict and that the purpose of the law. Stop. in the referral note, a division bench of this court has stated the very object of the family court is the expeditious disposal of the family matters. Yes. Family matters. Yes, it is not here. For purpose of reference, though it has been extracted in the note of difference, we may also revisit the statement of object and reasons of Family Courts Act 1984. Stop. The said statement of object and reasons reads as under, quote, several associations of women and other organizations and individuals have urged from time to time that the family courts be set up for the settlement of family dispute, where emphasis should be laid on conciliation and achieving socially desirable results and adherence to the rigid rules of procedure, and evidence should be eliminated. The Law Commission in 59th report, within bracket 1974, had also stated that in dealing with the dispute concerning the family, the court ought to adopt an approach radically different from that adopted in ordinary civil proceedings, and that it should make a reasonable effort at settlement before the commencement of the trial. The Code of Civil Procedure was amended in 1976 to provide for a special procedure to be adopted in suits or proceedings relating to the matter concerning the family. However, not much use has been made by the court in adopting this conciliatory proceeding, and the courts continue to deal with family dispute or in the same manner as other civil matters. The same adversarial approach prevails. The need, therefore, make it underline, is felt in the public interest to establish family courts for, quote, speedy settlement of family disputes, unquote. So it is obvious that the shortening the period of limitation falls within the ambit of speedy disposal. Therefore, the shorter period is prescribed under subsection 3 of section 19 of the Family Courts Act is harmonious to the object and reasons. And the Family Courts Act, as has been eloquently expressed in the object and reasons, has been enacted for a different set of purposes. Stop. We have acknowledged, we should recognize that various high courts have taken divergent opinions in this matter. Stop. But finally, the apex court has taken up this issue and given a quietus in Olnudashing versus Lee and Elton, colon 2021 SCC online SC 3285. Stop. The apex court has observed as follows. Quote paras 14 to 20. Stop. It has been emphatically observed by the apex court that by reason of the non-ostentive provision of section 20 of the Family Courts Act, giving overriding effect to the Family Courts Act, the period of limitation for filing an appeal from a judgment and orders of a family court constituted under the Family Courts Act would be 30 days and not 90 days. Stop. This declaration definitely falls within the within Article 141 of the Constitution of India, which becomes a binding law for all the courts in the country. Stop. In view of this, we answer this reference, holding that this Swarnalata, no, it's now you quote the entire thing now. We declared this judgment in Srimati Swarnalata Naik alias Nahak, Lily versus Manoj Kumar Nahak and another, 2017, 2 within bracket 2 Whaler 802, cannot be treated as good law anymore. Therefore, so where the limitation is concerned, the High Court shall go by the statutory provision of Section 3, subsection 3 of Section 19 of the Hindu Marriage Act.
Family Courts Act.
Family Courts Act, sorry. Family Courts Act. Stop. Before we part with the records, we express our appreciation for the efforts put in by the London Senior Council on our request, and we also record this appreciation. Stop. In the result, this reference is disposed of.
Well, appeal may be placed before the bench, my lord, you know. Appeal may be placed before the bench.
It's always there. Because in your case that we have applied this earlier judgment, now otherwise your limitation application will now be reversed. That we have allowed and say the appeal will go on. We segregated the matters. You just read. This will go because separate file has been opened.
Delay has been condoned, director reference has been made.
Yes.
We are obliged that.
No. Another observation we should add, write down before the parting with the records, that we would be failing in our duty if we do not know the anxiety expressed by the Land Council regarding the difficulties the people from the rural segment and any underdeveloped areas face filing an appeal before the High Court. In this regard, we should observe that while dealing with such application, the fundamental principles for condoning the delay should be liberally interpreted and substantive justice should be taken care of. Interest of substantial justice should be taken care of. Okay. Next, another matter is there. So what to do? This is a problem is that one honorable two division bench constituted of the same members has given a two separate decision. We'll say that we'll substitute their decision by saying that when the family courts, any amount will be deposited. Family courts or this matrimonial court, that amount has to be deposited before the court.
Yes.
In the name of the court.
Yes.
And the court will make the fixed deposit in any nationalized bank where the best interest can be derived. Right. So this way we just observe it. Because there is different practices are there.
When the amount deposited has already been released. The amount deposited has already been released to the white man. No, not in view.
That's a provision. Yes. How to deposit the money, yes. When the deposit can be released. So that, but we are concerned with the family courts matter.
Yes.
Here, next item.
That is the observation in the order dated 38/2023. To make a principle how to deposit and how to keep the amount. The page 5 of the order dated 38/2023, the last paragraph.
Already 38, no, this is
38.
paragraph 4.
Paragraph 4 that is the observation of.
This reference made to a larger bench to lay down a procedure for management of the deposit made in the family court proceeding. Stop. The judgment under reference, no, the order under reference, the order dated 38/2023, passed in MATA number 53 of 2009, Pranati Mishra, titled as Pranati Mishra versus Chandrasekhar Tripathi, where a division bench of this court has observed as follows. This court records the submission of Mr. Das and counsel for the respondent husband, that the respondent husband is ready and willing to provide further a sum of rupees 3,50,000 within bracket 3,000 by the next date. Let the respondent husband herein also deposit this amount by way of demand draft in the name of the wife appellant herein, considering the appeal is now confined only to permanent alimony aspect. Stop. In several other orders, we have come across that different directions are being made in respect of making the deposit. Stop. We lay down the principles in respect of making the deposit, management of the deposit, till the deposit is released to the party who has been declared entitled to get the said deposit. Stop. In cases where there is no settlement between the parties, court shall not accept any deposit in the name of either of the parties. The deposit has to be made in the name of the concerned family court or the matrimonial court. Stop. Even if after the final order is passed in a suit, the parties file an application of settlement in respect of their suit, which suit the family court or the matrimonial court can release the amount in favor of either of the parties. Stop. But when there is no settlement or agreement, the family court or matrimonial court shall not accept any deposit in the name of the parties. Such deposit shall be filed in the name of the court, and court, after considering its own order, shall deposit the said amount in a nationalized bank on term in the term deposit, which would bring or derive maximum interest, and for a period with flexible locking up. Stop. only after the dispute is finally settlement in terms of the appropriate court or the family court or the matrimonial court, the said amount shall be released with the accrued interest. Stop. For this purpose, the family courts and the matrimonial courts say open a special account following the procedure as followed by the Motor Accident Claims Tribunal under the Apex Court judgment. Stop. Before we part with the reference in terms of the above, we have come across that two conflicting orders by the same division bench has been marked for circulations to the family courts and the matrimonial courts. Judgments may suspended.
The first order was referred. First order was referred.
No, not relating to this case. Other conflicting orders are going down to the family court.
Manjit Kaur Manga, 2023 live law.
Just take down a citation in terms of the
KL Suneja and others versus Dr. Manjit Kaur Manga, 2023. SC 68.
Stop. For circulation of the judgment, they have also shown the subsequent decision that it is circulated to all the tribunals. There is a practice direction adopted by the full court of Orissa High Court in respect of circulation of the judgment. Stop. The said practice direction stands as follows, quote, "It is further resolved that in case it is found desirable by any honorable judge that the judgment is in any case is required to be circulated, comma, instead of passing judicial order regarding circulation thereof, comma, the matter may be brought to the notice of the Chief Justice on the administrative side for doing the needful." Stop, unquote. The extract of the said resolution was circulated. Stop. But the said resolution is not available in accessible records. For that reason, we have extracted this for observance. Stop. If the said practice direction is followed and adhered to, the various judgment with divergence dimension, circulation of the various judgment with divergent dimension can be avoided. Just record the name of the council, both the council, at the beginning. So in the above terms, this reference is answered, disposed of.
The matter may be placed before the assigned bench for the matter may be placed before the assigned bench.
It automatically go. Because we are not, that we have taken certain things only.
Yes.
No, already got it.
Yes, the first thing.